application, my lord. His mother-in-law is died, my lord. So today itself, my lord. Oblige, my lord.
My lord, I beg to mention item 50, my lord. It's a hearing matter. In the
Item
first hearing matter, in the first half, there is no chance of reaching, my lord. So I will be not in a position to remain present in second half. So it
all
may
matter.
kindly take care now in the so after 15th of January, my lord.
Okay, but it's all matter. Let's do it next
Of
time.
course, my lord.
Next time, let's do it. Please do it next time. You know, after I'll adjourn it. On the next date, kindly do it.
My lord, by the 1st of January, I will not remain present, my lord. First half.
No. Fix it after 15th only. But on the next date, let us do it.
Oblige.
The prayer of the learned council. Due to some difficulties in the second half of the day, he seeks an adjournment and prays for fixing the matter after 15 January. Full stop. The prayer is allowed. However, the learned council will endeavor to conduct the hearing on the next and
Much
subsequent
obliged.
dates as the revision is the all pending one. Is the matter when do you want any suggested date
By the third week of after Bihu days, my lord.
after due?
After Bihu holidays, my lord.
20 to 1.
Much obliged.
May I please lodge?
Thank you.
May I please lodge? Not item 41, my lord. Kindly pass over for the day, my lord. Let me take any date, my lord.
There is come.
Next, any date. my lord.
Interim is there.
Yes, my lord. Yes,
Interim is there.
yes, my lord. Vacation that may be.
No.
Friday up, my lord.
Interim is there. So how can it?
CDB send back.
No. CD interim is there. CD has
Interim.
come. So we should not adjourn it.
Yes, next week, Lordship.
Next
Next week.
next Tuesday. Let's dispose it.
My lord, I'll 19, my lord.
41 CDB retained. This is the matter next Tuesday. Interim shall be extended.
Hello.
Item 19.
19.
Yes, Lordship. Lordship, item number 44, Lordship. Diary not received.
No, item 19. So this was 41. 41.
May it please your lordship, back to mention for listing of a bail application today, 89 days, tomorrow it will be 90 days.
Okay.
Oblige your lordship.
Similar prayer, my lord.
Same case.
May I please, Lordship, item number 44, Lordship. Diary not received.
Diary is not received. I know.
It's an interim, Lordship.
I'm on India.
Diary is not received.
Diary.
Diary not.
There is press requisition for the case. There interim is extended till like this. This we can fix in January.
Lordship.
You know, suggest a date.
Lordship,
22nd.
can it be on 19th?
19/1.
Yes.
Deeply obliged.
May I please the lordship? Documented for listing of the anticipatory bail.
Tomorrow.
May it please your lordship, I beg to mention for a listing of a bail application. This it's a second bail application. Earlier it was disposed by your lordship.
Tomorrow.
Monday, lordship. And lordship, I beg to mention another listing for anticipatory bail application for Thursday. Much obliged.
May I please your lordship? Lordship, I beg to mention item number 43, lordship. Kindly adjourn for the day, lordship.
43. Diary has come. Case diary not received. Issue press requisition. Any interim?
Yes.
Interim extended till the next date of listing.
Interim.
Can suggest a date.
Lordship,
January
after vacation, Lordship, can it be on 20?
2021.
21?
21?
Yes.
21.
2001.
20
Okay.
January.
May I please your
Yes.
lordship? Lordship, I beg to mention item number 25. Your
Yes. Additional.
the advocate for the conducting counsel for the respondent is suffering from high fever.
No,
So praying for an adjournment.
it's an adjournment today as the leading counsel is unwell. When should we fix it? This
After vacation, your
this is the matter in the month of January. On a date to be fixed by the registry. And, any interim orders there? Probably not. Okay.
May I please, your lordship, item number 23 may be passed over for today.
23.
After vacation. Lordship.
Kindly inform the other side. if
Lordship,
you are-
I'm for the.
Yes, Lord.
The current council seeks adjournment of the matter with the consent of the other side, which is also present through learned counsel. Please the matter in the month of January, and the date to be fixed by registry.
Obvious, my lord.
If it does not get listed, then you make a mention. You can increase the amplification a little bit of this. No, it's more comfortable. Okay. It will be. Later also. Yes.
May I please, your lordship? This case, your lordship, the petitioner was arrested in connection with this case on 6th, your lordship, and originally arrested on 28/10, your lordship. Now, your lordship may kindly 33 days behind bar, your lordship may kindly come to page 17, the FIR. It's a long FIR, your lordship. Your lordship will find the name of the persons. Here, your lordship, petitioner's name were not there. And they belong to a group called P. Lasit Sena. And somehow, your lordship, all of a sudden, there is spate of affairs against these organizations, your lordship, in the month of October and November, your lordship. And series of arrests were done, your lordship, in various districts, members and leaders of this organization. All along, police has not found them involved in any kind of activities, but all of a sudden, these are all developments that had taken place post murder of Zubin Garg, your lordship. They have been raising certain demands, your lordship. And ultimately, this affair came, your lordship, by the CID. Your lordship will kindly find page 17 is the affair starts with. There is a
It's being investigated by the CID.
this is by the CID. And there are other cases also. They are probably, your lordship, after going through the FIR, it looks like they are investigating the larger conspiracy, your lordship, involving.
Also the case that
CD is
Lordship, before vacation, your lordship, and it's from CID, your lordship. And they are behind bar, probably your lordship will find, your lordship. Their names were not there initially, and there is no specific act attributed to these two petitioners, your lordship.
anyway, so heard. So what about learned? And SH Bora learned additional paper. All for the case diary of CID PS case number 20 of 2025. Industrial section. The two petitioners seeking bail hearing under 483 BNS, namely so and so and so and so, were stated to have been shown arrested in this case on 6/11/2020. Okay. You can suggest a date. You want it before
19
vacation.
at best. On 19.
Last date.
Yes.
Yeah, keep it one thing.
Lordship, on 18.
18.
No, I think it's keep it on 17th.
Lords,
Because,
7.
it is very voluminous thing. You need some time to get to it.
Deeply obliged.
17.
With me, your lordship, so regular bail application, your lordship, charge-sheeted case, your lordship. Petitioner behind the bar till 78 days, your lordship. So TCR kindly be called for.
Scan copy of.
What is the section?
Sec-
Trafficking.
Trafficking, your lordship.
Trafficking. Heard. All for the scan copy, scan TCR comprising case diary and charge sheet of sessions case number 165 of 24 under 370 371 IPC pending before learned session just Sony within bracket arising out of Deshpur PS case number 1501 of 2017. The accused is in custody since stated to be in custody since 22/9/2020. List the matter on
7/1. 7/1.
we'll face a problem with regard to the, this
Lordship,
BAs, regular bail applications.
Lordship,
Because after vacation becomes a little long for BA custody bails. At the same time, before
Lordship.
vacation also it's
Secretary
very
will-
crowded. Hmm?
Well, unemployment is likely after vacation.
After, can I fix it in after vacation?
After we.
After vacation. This is the matter
As per your lordship convenience.
immediately after reopening. Immediately after reopening, 5-1.
Lordship.
This because of the holidays in between, we face this problem.
Lordship. Lordship.
Regular bail should be fixed within a.
May I please, my lord. Regular bill application, my lord, can you see the FIR is page 13, my lord. My lord, in this case, my lord, allegation against us is that, my lord, recovery of lordship fake currency and, my lord, preparation for lordship dacoity.
Okay, go ahead.
My lord, absolutely lordship false FIR. Can you see the lordship seizure list, my lord? Last paragraph, page 31, my lord. Page 31, my lord. With the seizure list, my lord. Start page 30, my lord.
FICN.
FICN, my lord, 98,500. My lord, from home position, who is legal, how much currency was recovered, that is nothing, my lord.
It's a continuation. This.
Lordship. Has been recovered from the possession of the petitioner.
Not, my lord.
This is a continuation of the earlier part.
Lordship city will be.
It starts from 30 anyway. At this stage, let us look at the case there.
My lord, I am 35 days lordship behind them. There is nothing, my lord. Can you see the, my lord, FICN 98,500 from whose vehicle, whose possession, how much currency was recovered, that is absolutely missing, my lord.
City will reveal everything, Lordship. Let us. Yes.
Totally false allegation, my lord. Otherwise, my lord, 2 bamboo sticks recovered from the vehicle, my lord. This is not objectionable items, my lord. Absolutely missing, my lord. 98,500,
So and so
7
from-
accused person, lord. 2nd
Recovered
accused
from the
person.
possession of Ainul Haq, Alaluddin and Amir Hussain. It's a description of all these articles. The description of the FICN has been given on the next page. Anyway, see the diary. See the diary. Call for the case diary of Pokishta PS case number 537 or 25. Section. Both the petitioner seeking bail here stated to have been arrested on 4/11/2015. This is the matter of 5-1.
Lordship.
My lord, before vacation, my lord, if possible, I'm behind the 35 days, my lord.
5-1.
My lord, 19, my lord, last date, my lord.
Too many cases
My
are
lord.
wasted on 1980.
My lord, 19, if possible, my lord, 19.
Many unlisted matters there. To do.
False FIR, my lord, 19, if possible, my lord, kindly give it
18,
19.
one.
18, my lord,
Sorry,
18,
18, 12.
18, my lord.
May please, your lordship. This is a regular bail application, lordship. In this case, so for petitioner, lordship. Original FIR page number 20, lordship. May I read, lordship? Page number 20, lordship. May I read, lordship? সন্মানপূৰ্বক বিনীত নিবেদন এয়ে যে আজি ইংৰাজী 26/11/2025 তাৰিখে নিশা প্ৰায় 10 মান বজাত মোৰ নিজা ঘৰত অপপক্ষগণে প্ৰৱেশ কৰি মোৰ বিভিন্ন অশ্লীল গালিগালাজ কৰাত মই বাহিৰলৈ ওলাই যোৱাত মোক ঠেলা হেঁচা কৰি অপহৰণ কৰাৰ চেষ্টা কৰে। তেতিয়া মই ভয়তে চিঞৰ বাখৰ কৰোঁ আৰু চিঞৰ বাখৰ শুনি ওচৰ চুবুৰীয়া লোকসকল ওলাই অহাত মোক অপহৰণ কৰিবলৈ অহা ব্যক্তিজনে মোক এৰি চিঞৰি কয় অহা এসপ্তাহৰ ভিতৰত নগদ 2 লাখ টকা তেওঁলোকক মুক্তিপণ নিদিলে ভৱিষ্যতে হত্যা কৰাৰ ভাবুকি প্ৰদান কৰি উক্ত স্থানৰ পৰা পলাই যায়। This is the FIR, lordship. Lordship, petitioner number 1 is the chairman of a organization, lordship, Liberal Democratic Council of Missing Land, lordship. And petitioner informant, lordship, informant was the ex-secretary of this organization, lordship. Recently, he is terminated from his post, lordship. That's why he lost FIR against the petitioner, lordship. Information is received, lordship. Gugamuk Police Station filed charge sheet lordship.
Already. Charge sheet already filed.
Charge sheet. Within 4 days lordship, they filed the charge sheet lordship. Charge sheet number 114 lordship kindly consider lordship the petitioner informant to the law.
This is a lawful organization, Liberal Democratic Council. It's not.
Yes.
Yeah, pardon.
Scan copy of TCR may be got.
Is there?
Scan copy of TCR because the matter has been surseated.
Have you annexed the charge sheet any chance?
No, lordship, date of charge sheet 13/7/11/2025 lordship. Lordship kindly consider lordship they are
Not at this stage.
only 4 days.
When can we, they were arrested on 26th.
Arrested or arrested on 26.
I'm trying to
26th,
gather this. So. All were arrested.
All were arrested lordship.
The 4 petitioners herein seeking, invoking 483 BNSS are seeking bail in connection with Gogamut PS case number 123 of 25 in the section so and so. They were arrested on 28/11/2024. No, 26. Sorry, yeah, 28/11/2024.
2 days of police custody.
And presently in judicial custody, and stated and submitted that they were also in police remand for 2 days after arrest. Full stop. The case is stated to have been charge sheeted. When can we get it?
Lordship, it will come through registry, Lordship.
Because depends, it may not necessitate long detention.
Lordship, charge sheet already filed, lordship.
That is
kindly
fine.
consider custodial detention is not required, lordship.
Or Lordship may let him appear
Election
before
is
the
to
trial
take-
court also, Lordship.
No, this trial, would you approach trial process?
Lordship, direction may be given, lordship, kindly consider, lordship. Already
Yes.
charge sheet has been filed, lordship, within 4 days, lordship.
They will come
Allegation is
back
totally
according to
false and
law.
fabricated, lordship. Allegation is totally false and fabricated, lordship. Kindly
The-
direction may be given to consider the bail application. lordship.
At this stage, the learned counsel also submits that perhaps he may also be given the option of approaching the learned trial court for bail. Allowing the said prayer, the instant bail petition is disposed of with the observation that the petitioners may approach the learned court below seeking bail. No sessions tribal section, right?
Session tribal section is there, lordship. 140 is also there, lordship.
At the moment, this is with the magistrate,
Magistrate, lordship.
so that may be a problem.
No.
Custodial detention is not required, lordship. Charge sheet already filed, police take 2 days of police custody, lordship. Within 4 days, lordship, they filed the charge sheet, lordship.
Then scan copy.
Lordship, kindly consider the length of detention. As on day behind the bar, lordship, 14 days, lordship. Our allegation is totally false. The informant was the
Invisible
It
right.
is submitted by the,
That's goes of.
delete that. You delete. Last line it is submitted by the petitioner that charge sheet was filed within 2 days. That's why I asked, this is a lawful organization. Call for the scan copy of the case record of Gogamuk PS case number 123 of 2025. Comprising the case diary as well as the charge sheet. The perusal of which is considered necessary to determine the final outcome of this bail petition. However, the given circumstances, or till the same is decided, perhaps the under trial detention of the petitioners can be put on hold. In such view of the matter, it is directed that in the interim, the petitioners are allowed to go on bail of rupees 20,000 each, with the surety of the like amount reached to the satisfaction of the concerned learned court, CJM,
Remaji, lordship. Remaji.
and subject to the conditions that they shall be available for trial on commences. They shall not hamper or tamper with evidence they shall not in any manner intimidate, harass or harm the informant. Full stop. Then we can fix it after the petition.
Lordship.
After the petition. This is the matter in 21-1. Any other date you want? Sir?
Lordship, 21.
21-1.
Lordship. File of Lordship.
Mid Pieces Lordship. My lord, in this case, petitioner is behind the bar for 33 days, my lord, as on today. And the translated copy of the FIR is at page 8, my lord. The informant, who happens to be the brother-in-law of the petitioner, my lord, alleges that his sister, my lord, who died at hospital, suspects are of foul play, and based on such suspicion, my lord, that present FIR was filed. And they have a daughter also, my lord, who is aged about just 1 year, my lord, old. And there is no one to look after the child, my lord.
Allegations about dowry.
Yes, my lord.
They were arrested on.
He was my lord, arrested on 6/11.
This will need the CD. Call for the case diary of Sri Bhumi PS case number 483 of 25. He is the husband.
Yes, my husband.
The petitioner Samsud be stated to be the husband of the deceased. Is seeking was arrested. Is in custody after his arrest on 7/11/2015. Please the matter on the day of reopening. on
My lord,
five-
before
five-
vacation, try, my lord.
I don't
Kindly,
know.
lordship,
No,
because
no.
1 year old daughter, my lord. That is why we are making a
6/1, Lordship.
my lord, kindly on 19/11, my lord, or 18/11,
No, no,
15/12, my lord.
Let us avoid last 2 dates. Otherwise you can fix. If then we can manage. Otherwise it may be unmanageable, right? You will not. You have to get the orders. It has to be uploaded.
6/1.
17 also, my lord. Kindly, lordship.
What to do? You guide me.
It's from Sri Bhumi,
Sri
Lordship. It
Bhumi,
will
ma'am.
not come.
Hmm?
It will not come.
There'll be so many matters. 483. There'll
6.
be so many 483 matters.
Yes, Lord.
Can we fix it in the next 2 weeks?
Lordship,
Will it be possible to dispose it?
Let
Let
us-
us to work late, no problem. But the thing is that will it be possible?
Lordship, 5,
The whole
5,
process has to be there
5,
to get the orders.
5/1 or 6/1, Lordship. Just after reopening.
Let's try, my lord. Lordship, we can give a try, my lord.
17,
18 also,
18,
my lord.
19, Lordship, it will be difficult. Only 1 week left. Too many cases.
This one, let it be on 5.
5,
So
Lord.
the nature of the
5, my lord. kindly.
5 on.
5/1.
Will case to case basis we have to decide.
No,
Case to case
along with the postmortem report.
along with the PM report.
May I please, your lord? 483 an application, my lord. He was arrested on 13/10/25. Today he has completed 58 days, my lord. And in connection with the Badarpur PS case number 186, I take your lordship the FIR at page, my lord.
12.
Yes, my lord, kindly. Page, FIR is at page, my lord, 12, kindly. My lord, it is a allegation is that 306, the informant sister has hanged herself inside the room. But in the FIR, it has been alleged that there is a love relations with this boy. This is accused, and my lord, the deceased used to help the boy with the financial help, my lord. And he also mentioned that they have come to know that this boy is trying to marry other girl, and which might have caused the such tragic death. My lord, 306, your lordship know, there are a series of judgments of the Apex Court and the High Court, my lord, which I am placing to Mohendra Wise and the Ayub others by the Supreme Court, but it has been specifically mentioned, my lord, that 306 when it will be applicable, my lord. So in this case, there is no such material available that I am involved, and I have instigated her to commit suicide, my lord. So when it is absent, my lord, the case section 306 will not apply. It is a mere case of committal suicide, my lord. Probably out of her frustration or anything, whatever might be the cause, my lord. So, my lord, 58 days I have completed. Statutory period is 60 days, my lord. Your lordship may consider the bail under any consideration.
We'll take instruction, Lordship, whether CS has been filed on.
We call for the case diary and fix it day after tomorrow.
Lordship.
Yeah, you can
Yes.
take
That day I will be completed 60 days, my lord. I will
Yes,
get
and
the
that-
bail there also will work out if I could have filed this man. I've come over here. As out and out, there is no material against me, my lord. 306 will not apply. Even if case is charged, it cannot be convicted.
Yeah, you take instructions when can we?
My lord, today
Day
my
after-
sister can take instruction. Today itself at
Day
2
after
p.m.
Tomorrow CD may be
No, take the, can you take instructions today? Just,
today.
regarding charge sheet.
So that, right?
Even if charge sheet also, your lordship can get the bail, my lord. There is no hindrance at all.
Let it be fixed on tomorrow.
Someone has died after all.
Yes.
Yes, I understand. This appears to be prima facie a case of very unfortunate,
Yes, it is all committal suicides are unfortunate.
No,
my
no,
lord.
betrayal in love and,
But that is there. It is a common
heartbreak.
feature, my lord.
Heartbreak.
Yes.
So for that, this boy cannot be in,
But no, abatement
entangled.
is a different matter, of course. So now I was proposing to fix it day after tomorrow, and then he either we get the instruction or he gets paid. That's the thing.
Lordship,
That's what I was thinking.
Yes.
Anyway,
Whatever is convenient for the.
just 2 days only.
Yes.
Or
Lordship directs
if
us
sorry
to bring
insists,
the
then
CD.
tomorrow you take the instruction.
Yes, Lordship.
Tomorrow I will not be here, my lord.
Not be here.
Day after tomorrow.
The third petitioner was arrested on 13/10/20.
My lord, in this case, I would like to draw your attention for one thing newly. My lord, BNSS, there is section of 37, my lord. Kindly peruse the BNSS book, my lord. 37.
BNSS.
Yes. Which is not being followed nowadays, my lord. Kindly come to section 37. Designated police officer.
BNSS. 507.
The 37, my lord. Section 37. You got it, my lord?
Yes.
37. My lord, the state government shall, very important,
Mhm.
establish a police control room in every district or at a state level. They designate, number B, they designate a police officer in every district and in every police station, not below the rank of assistant sub-inspector of police, who shall be responsible for maintaining of information about the names and address of the person arrested, nature of the offense, with which charge, which shall be prominently displayed in a manner including the digital mode in every police station and at this district headquarters. And my lord, if your lordship peruse this diary, then your lordship will confirm that 47 and 48 has been followed or not. But this is not being done still today in the state
What
of
is the
Assam.
meaning of digital mode?
Yes.
In the police station or website?
Police station in every district of police station.
In the digital mode means in the display board.
Yes.
In the police station.
Police station.
Because if the list of arrested persons is put on the website, I
Yes.
don't know, it may be already. There is also a question of privacy and dignity.
Yes.
Because an arrested person is presumed to be innocent,
Yes, otherwise.
isn't?
Lordship.
So my lord, it is a share, my lord. It should be followed, my lord. Otherwise,
Subject
all
to that,
arrest becomes illegal, my lord.
because
Then Lordship, let it be on 11, 12.
yes, his sorry is not there tomorrow. We'll see, there's
So CD or instruction? Lord?
13/10/2025. In connection with Badarpur PS case number 186 or 25. The learned counsel submits that on a bare reading of the FIR, the ingredients of section 30, what is the new section? 10
108.
108/308 subsection 4 BNS is not made out. Full stop. Call for the case diary. List the matter on 11.
Lordship.
These two judgments I'm keeping.
Yes. My lord, these two judgments are very, very important, my lord. Our High Court judgment also there, my lord, on this point.
7.
May I please, Your Lordship? My lord, the three petitioners before Lordship seeking to release on bail in connection of Pathargandhi PS case number Lordship 229, 2025. FIR Lordship at page 10.
Hmm.
Here, my lord, 1 Badrul Haq, to 3 Kamrul Islam and 6 Abdul Jabbar before your lordship. They were arrested and on 15/10/2025 and till today, my lord, 54 days behind the bar. And there is also cross case against the present informant. And on the same day, my lord, that is, my lord, also taking into account
Do
to
we call for the case diary of this one, only this one?
lordship.
Yes, Lordship.
And lordship, another case, my lord, AB number 2883/2025,
Same.
fixed on 17 of this month.
Yes.
17
We
of this.
can have it together.
Lordship.
Take together, lordship. AB number 2883. On
Call for
17
the
of
case diary of
case diary, my lord.
PS case 229 of 2025. Stop. The present accused was stated to have been arrested on the present accused petitioners.
Petition number 3 on 15/10 and 1, 2 on 16/10.
Yes, the petitioner number 1 and 2 were stated to have been arrested on 16/10/25 and petitioner number 2 on 15/10/2020. Leave the matter on 17/12/2025 along with AB number
2883.
2883 of 2020.
CD along with injury report.
Case diary along with injury.
Injury report. Obliged.
Lordship. So it is a FIR plus 12 lordship. Petitioner arrested on 13/10/25 lordship. Agent total 57 days. 109 is there. FIR plus 12.
Diary at this stage?
Yes. From Kamalpur lordship, Kamrup.
Call for the case diary of Kamalpur PS case number 123 of 2000. The accused was arrested on. The petitioner was arrested on 13/10. Please the matter on
Lordship.
13/10,
Friday.
13/11. What is the statutory period in this case?
90 days lordship. 109 is there.
90 days.
11, 12,
And
1. 13 January it will be over.
Lordship 18 December maybe given.
first week of January, Lordship.
5.
Lordship this month
5/1.
was given lordship.
Or, huh?
5/1.
5/1.
Yes.
You can, or we can fix one or two, some matters in the vacation times also. I don't know the dates.
5/1, Lordship.
Have the dates come? The vacation
Dates
times?
not come.
Lordship.
9.
May it please your lordship. My lord, here 45 days as of now, my lord, both the accused persons. My lord, without going to the merit right now, my lord, because one Manoj Kumar is supposed to be the prime accused in any manner, my lord. I just pray, my lord, a shorter date for case diary, your lordship. Because otherwise, my lord, these two are only employee to one Manoj Kumar, and the allegations are that against Manoj Kumar, my lord. That can be, my lord, find out from the FIR itself, my lord. So, Manoj Kumar mara nai. Into mara nai. Allegation of some forging of documents, my lord.
Petitioners hearing were arrested, stated to have been arrested on 25/10/2025. 60-day offense or 90-day?
90 days, my lord. New inclusion, my lord, that for that, my lord.
Call for the case diary of Bokisto PS case number 521. Take it on 5.
My lord, can it be in the vacation bench if it is not?
Yeah, vacation bench it can be, but date I do not know.
My lord, if my lord.
That's why I asked. I'm not.
Yes. Then, my lord,
It's not, list has not yet come.
Not yet.
my lord, may I pray one thing, my lord?
Yes.
Not on merit, my lord. Since there are 45 days, my lord, and only on suspicion, any date before vacation, my lord, let it, because it's Bokisto Thana, my lord. PS is Bosista, my lord, from Guwahati itself. Let us take a chance, my lord, because
17.
yes, my lord. Deeply obliged.
17.
Deeply obliged.
I want to accommodate everyone, but we'll work late last week, no issues. But within limit-
Lordship, CD may be called for Lordship.
this is charge sheet, yes, no, CD.
CD Lordship.
Call for the case diary of Bhisto PSKS 470.
75 days.
He's 19 years. Aged.
Lordship, 90 days Lordship.
Arrested on 29/9. What is the allegation?
Lordship, as per FIR dated 11/9/25, the victim was beaten with blows and hockey stick, but the present petitioner is nowhere involved. His name is also not mentioned.
Allegations are a bit serious. The petitioner stated to have been arrested or taken on 29/9/2020. Call for the case diary from the concerned police station. Fix it on 18/12.
Lordship.
18/12.
Much obliged.
May I have your lordship? Lordship will find the FIR at page 16. Lordship, may I read the FIR, lordship? On 11/11/25, it was lodged by the police personnel. On 11/11/2025, while I was on duty with the ERSS 112 vehicle of Gorsuk Police Station along with AB so and so, at about 3:43 AM, telephonic information was received from the police control room that one person suspected to be a thief has been detained by some local persons near the Havel showroom near CPWD office, Gorsuk. Accordingly, we immediately proceeded to the spot and found one male person in weak condition being held by the local public. The said person was brought to the Gorsuk PS for necessary action. On being asked, he disclosed his name was Prahlad Kolita, 39 years, son of so-and-so. Considering his physical condition, he was taken to so-and-so hospital, Pamohi, for medical treatment and examination. At about 9:39 AM, his health condition started deteriorated again, for which he was taken back to the hospital and subsequently referred to GMCH for further treatment. Later on, at about 7:30 PM, information was received from GMCH that the said person has expired while undergoing treatment. Later, SI so-and-so of Gorsuk PS examined the CCTV visual of Havel showroom, which revealed that a group of local persons were seen assaulting the said person with sticks while detaining him, which indicates that the injuries sustained by the deceased were crossed prior to him being brought to the police station. Later on, some of them were identified as Lordship. I am at serial number 3, Manoj Nath. Lordship, these persons were arrested. All of these 5 persons were arrested. And Lordship, bail application was filed on behalf of 3 of the accused. Lordship will find that at page 20. And Lordship, this honorable court has granted bail to the 3 accused persons who had preferred the bail on the ground that the CCTV, that the post-mortem report does not indicate any external injury. Lordship will find that at page 21. May I read from para 3, Lordship?
Just a minute. I'm reading it.
Lordship.
Okay. Again, we have to see the diary. with regard to
Lordship,
this.
I have inquired, Lordship, the case diary is apparently here in the High Court itself. Lordship, can it be taken up at 2?
No, not true.
Lordship, because the other persons, after considering of the case diary, were only released on bail.
Yes, that's true, but case diary is perused with specifically with regard to different persons, right? So since this person was not before.
But then may I pray that it may be taken up at 2 today, Lordship, because
My lord, not possible.
or Lordship, then tomorrow morning.
So many matters. Call for the case diary of Gorsuk PS case number 304 of 2020. Is submitted by the present petitioner was arrested on 12/11/2020. Is submitted that three co-accused were granted bail by this court by the order dated 3/12/2025 passed in PA 3710 of 2020. And it is also contended in this regard that perhaps the case diary is still available in the bookstore. Call for the case that the registry may also look into the availability of the case diary. Registry will look or your office?
No,
We will-
if CD is available, may such it not filed, then I will have to check. Otherwise,
Not registry, right? Your office.
yes.
DPO.
And if returned back, well, then.
Day after tomorrow?
Lordship, can it be tomorrow, Lord?
Day after.
Yeah, tomorrow. All right.
11:15.
May I please, Your Lordship? Well, this is the second bail application. my lord. Earlier bail application was rejected, my lord, on 51/11/2025. Your Lordship, kindly see page 18. Sorry, my lord, page 19, paragraph 9.
The determination on the 37 was not made, it seems. Was it made?
My lord, Your Lordship,
It is under investigation,
yes, ma'am.
madam, still under
Yes.
updated case there. Call for the updated case there. He's arrested on 12/7. Anything else?
12/7/25, my lord. was the-
The petitioner herein seeking bail was is stated to have been arrested on 12/7/25 in connection with NCP Guwahati crime number 8 of 25. So, submitted that an earlier bail petition was rejected by this court on 21/11/20 in BA 3499 of 2020. Call for the updated case diary. The case is stated to be at the stage of investigation, still stated to be at the investigation, stage of investigation. Call for the updated case diary. Please count 551.
Bless her.
All right.
Wait, please. Type is FP application, my lord. FIR is at page 12, madam. The allegation, my lord, such that on account of love affairs, it was suspected that due to the provocation given by the petitioner, the victim has committed suicide, madam. Page 12 is the FIR, madam.
I've seen short.
He is a
What is-
student, 20 years old, my lord. He is a student of Polytechnic, my lord, Kolkata Polytechnic institution, my lord. And so far the allegation is concerned, my lord, this is the only the allegation the suspected on account of their love affairs, he might have committed suicide. So 108, my lord, section 108 my lord, incorporated. 60 days is the my lord,
Yes, I understand.
40 days already he is behind the bar, my lord.
Call for the case diary of Morigaon PS case number 268 of 25. Accused was arrested on 31/10/2020. Release the matter on 17/12.
My lord.
17.
My lord. How like it?
May I please, your lordship? Lordship, my senior is in late lordship. Kindly pass
Just
over
some
for the time.
Rapid loss. My lord, in this case, my lord, two brothers and their nephews were, my lord, arrested, lordship, detained, my lord, at, my lord, on 3/11/2025 at 1:44 AM, lordship. Actually, it was, my lord, on 2/11/2025 at 10 PM, lordship. My lord, 16 hours, my lord, from the date of detention, taking custody, my lord, they were illegally detained, my lord. Thereafter, a case was registered, my lord, and they, my lord, they were, my lord, formally arrested,
This
lordship.
is the allegation.
Allegation at page, kindly see at page
Fake currency.
9, lordship.
Decoity, my lord.
Page 9, kindly see the FIR, lordship.
Yes.
Lordship.
We have fixed another case, I think. This-
Regarding the
yes,
prison.
I see.
Well, this is absolutely, my lord, violation of Article 21 of the Constitution of India. After 41 hours, lordship, of detention, lordship. The petitioners were, my lord, produced before the magistrate, lordship. My lord, as per Article 21, my lord, it should be, my lord, within 40 hours, 21 hours, lordship. Sorry, 24 hours,
24.
lordship.
Where is it? Where was it? When were they detained? We
My lord,
fixed,
in the affair, my lord, kindly see in the affair itself, last at page 9, lordship. At page, kindly see at
The city
9, my lord.
city-
Accordingly, the following persons were
apprehended and taken into custody. My lord, custody means police custody, lordship. My lord,
Police custody can be given by.
they
court.
were, my lord, locked up, lordship. Unless they were formally arrested, my lord, they cannot be, my lord, put into, my lord, lock up, lordship.
Anyway, so we have fixed, I think kindly check whether this is Boras. The FICN case, that fake currency, FICN, what is the PS case number of that? Bohisto PS 537? Bohisto PS 537, there is a different.
I think 3 was there, lordship. Yes.
Eighteen.
This is PS 537.
One this,
Five, the same case. Same day.
one this.
Call for the case diary of Bohisto PS case number 537 of 25. That's so and so. The present three petitioners seeking bail were arrested on 2/11/2025. List the matter on 17/12/2025 along with PA number
3927.
3927.
Yeah.
2020.
All right.
18/12.
Where I got the key.
No, this is a
18,
18,
12.
18.
Well, in this case, earlier one instruction was sought for regarding whether any FIR laws against the petitioner or not. Well, till now, I have not received any instruction. You will see, may kindly fix it tomorrow or day after tomorrow. I'll get the instruction.
Tomorrow, my lord.
Yeah. The instruction as called for has not been received and the learned additional people seeks some more time, which is allowed. Tomorrow,
My lord.
Yes.
list the matter tomorrow. 10, 12.
That legal. One petitioner before your lordship, my lord, earlier it was 498A, my lord. Now it is section, my lord, 85 of BNS, my lord. After, my lord, 18 years of marriage, having child of, my lord, around 15 years, this case was lost by. In the year 2007, my lord, the marriage was solemnized, my lord. Recently, when petitioner before your lordship was, my lord,
Where is the Abraham?
Ejahan, my lord, page 9 and Annexure 1, my lord.
The allegations are prima facie taken, they are on the serious side.
Yes,
Because-
he's accused number 1. He is the husband. Nowadays, my lord, some my lord, allegations are made, my lord, to make the case complicated, my lord.
So I don't know about that.
But nothing is specific, my lord. But here, my lord, before 16, 17 years, my lord, that stayed together.
AM Borbia Learned Counsel went, invoking section 482 BNSS, the petitioner is seeking anticipatory bail in connection with Hailakandi PS case number 145 of 2025 under so and so section. Full stop. The FIR has been lodged by the informant / wife against her husband, who's the petitioner herein, and 3 other members of his family. So the allegations are about commission of cruelty and harassment upon her. It is also alleged that husband is having an illicit relationship with another woman, and that is one of the reasons why he is inflicting cruelty upon her. The petitioners stated to have been married for 16, 17 years and also have a child of 14 years. Call for the case diary, the concerned police station. However, in the interim, in the event of his arrest, 25,000 once saved. Number one, he shall cooperate investigation, record his statement. Number two, he shall not in any manner commit any harassment, torture, or cruelty upon the informant in any manner. Violation will entail cancellation of interim bail. Please the matter on.
On 5-1
Let it be later.
Oh, yes.
Hmm?
Okay.
21-1.
21-1.
We need some space.
Deep level.
May I please allow? But it is an application of 483, 82, my lord. My lord, what happened, my lord? The informant Salman Hassan Lashkar, page 17, my lord, kindly Sparrow's FIR. He used to sell inside the market, my lord, a small packet of drugs. All these, there are 18 petitioners who are there before the court below. They are all members of Rashtriya Swayamsevak Sangha as revealed from the FIR, my lord, page 18. These people are, what about, they have warned him not to sell the drug and not to come to the market. And for which, my lord, he has filed this FIR that we have snatched away 9,500 and he was tied with the rope, my lord. This is the allegation. Learned Session Judge has granted bail to all the persons, my lord, except the petitioner 1 and 2. So what I pray, my lord, kindly call for the CD and give us some protection, my lord. We will give our statement, my lord, that we being a member of RSS, we cannot do this extortion. All these sections are available except 308, my lord. That the
Who are selling drugs? There's no NDPS. There's this informant side.
yes, informant. He used to come to market, my lord, with small quantity of drugs. He used to give the children, young boys, my lord. That we have warned him in the Amarghat Bazaar in the Kachar district, my lord. And for which, my lord, he has lost the affair that these RSS boys have threatened him and wanted to kill him and snatch away rupees 9,500.
Whatever it is, nobody should take law in their hands, and it should be informed to the police. Anyway, they were granted regular bail or 480.
But there were otherwise we granted bail, pre-arrest bail, my lord, except these 2 persons.
Third, this was Land Council.
There are 7 persons.
My lord, may I kindly come to page number 21, my lord. Page number 21, my lord, third paragraph, my lord.
They were injured. Page?
Page 21, third paragraph, my lord.
Third paragraph. Yes.
It is, my lord, after perusal of the case diary, my lord, their bail were not considered, my lord.
Yes, that I have submitted. Others have been granted bail except 1 and 2.
Demanded 50,000.
Yes.
Also. Anyway. That's true. Anyway, nobody should take law in hands. S.C. Biswas and R.J. Board. 482 bail BNSS. Taking pre-arrest bail in connection with Achudaram. PS case number 48 of 22 under section 20. These 2 petitioners. The elaborate. Elaborate leakage. Mark. The gist of the allegations in the FIR dated 6/11/2025 is that the FIR named 7 accused persons named in the FIR and 10-12 other persons on 4/11/2025 called the alleged victims towards one 7-star club at Amarghat Bazaar, and thereafter tied them up and assaulted them, and also snatched away certain valuables, including a 2-wheeler. It is alleged that as a result of the assault, they sustained injury. The learned counsel commits that the informant side, the informant, the alleged victims used to come to the market to sell uh, narcotic drugs in small quantities to young persons, and therefore the accused persons named in FIR had registered the same and but it is contended that the allegations of assault are exaggerated. Full stop. It is also drawing attention to the annexed order dated 28/11/25. It is submitted that the other petitioners, the other FIR named accused persons were granted pre-arrest bail by the learned court below. I peruse the order. However, the bail prayer of the present petitioners before the learned court bill was rejected. Call for the case diary. Call for the case diary of so and so. In the interim, in the event of the arrest of the petitioner, 25,000 security, corporate, appear before IO, shall not hamper or tamper with effects. Number 3, they shall not misuse their liberty to take law into their hands and or commit any illegal activities. This is the matter on
22-1, my lord.
it. I was just
Deep problem. May I please, Lordship? Lordship, this is 482 application, Lordship. In this case, Lordship, the FIR will find page number 13. And Lordship, some cash money and some golden ornaments has been recovered from the FIR name accused number 1, Lordship. And allegation only, Lordship, and I have provided this gold and cash money to him. This allegation only against me, Lordship. And all these things, Lordship, recovered by the police, Lordship. And so, my Lord, my little submission, Lordship, I will forward and I will be appear before the IO, Lordship. I have page number 13, Lordship, operating person, Lordship. May I read, Lordship?
No, I'll just go through.
Lordship. There is nothing whispered against me, Lordship, at all. And recovered and seized by the police, Lordship. And police lodged the FIR. Not by the any individual person lodged any FIR or
Lots of
complaint.
ornaments, huh? Lots of ornaments found.
Lordship, there is no any individual person, Lordship, lodged any FIR or complaint before the police station or anywhere else, Lordship. And police lodged this FIR, Lordship, and only received the confidential information, Lordship. This article has been recovered from one Shahizul Hussain Soikia, Lordship, and from his house, Lordship. So, my Lord, and he only one statement given, he give this some. This
At this stage, I think we'll have to call for the case diary. Any submission from your side?
My lord.
Any submission from your side?
No, my lord, this is the material against him, my lord, page number 14, my lord.
Hmm.
My lord, article recovered from my lord.
Shahizul.
Yes, my lord. Shahizul said, my lord, he has implicated this person.
That's true.
So, my Lord, Lordship, I may be cooperate, Lordship, and I will be appear, Lordship.
No, interim would be difficult.
And page number 15, Lordship, I am the reputed person, Lordship, and I am doing the business, Lordship.
Call for the case diary of Sargaon Police Station, PS case number 326 of 20. In the so-and-so section.
And so far, section is, Lordship, there is nothing.
Well, this matters. Call for the, this is the matter, suggested it.
My lord,
16 or 17, Lordship.
On the day of reopening, 6/1.
Lordship, I'm sorry, Lordship. Can it be, Lordship, before
AD
vacation?
has to be.
Lordship, it is from Sargaon, Lordship.
No, 6/1. Will be difficult. The priority is BA.
Lordship, I'm sorry, Lordship. Can it be, Lordship, 18, Lordship? 18?
No. I would accommodate otherwise.
Yes, it's interim is not there, Lordship, and
It will be unmanageable. So many
May I-
BAs to be fixed.
Okay, there are 5 petitioners before your lordship. Petitioner number 1 is the prime accused, others family members, married sisters, brother-in-law and mother.
Mhm.
And my affair at page 16 maybe
Yeah.
10, Lord. Basic allegation against the petitioner number 1 is that, Lordship, he deceitfully established physical relation with the informant, Lordship. Informant is a divorced lady and the present petitioner is 19 years
and so-called victim is Lordship 26 years. And Lordship kindly see the allegations, page 16. FIR itself is my defense, Lordship. Informant's Lordship, initially FIR was refused to accept by the police. Thereafter, this FIR directly lost to the Superintendent of Police, Dhubri, Lordship.
Who are they actually? Can you just read this? Can you read the original FIR?
Yes, Lord. Page 16.
A 90, that boy supposed to have a relationship.
Yes, Lord.
With this.
19 years boy.
Yes.
Case number 1, my lord.
Whatever
Case
it is.
number 1.
But, okay. And how did the others get involved?
Lordship, the informant Lordship went to the house of the petitioner number 1. Then they driven out the informant from their house.
The petitioner number 2, 3, 4, and 5 are
My lord, that lordship will
yes,
come,
married
will
sister.
find my
family
lord.
members of the boy.
Boy.
Family members of the boy.
On the page number 16, my lord. Lordship may kindly come to down below, my lord.
Yes.
মানে ঘটনাৰ পিছত 2, 3, 4, 5 নং আসামীয়ে পৰিকল্পিতভাৱে চক্ৰান্ত কৰি মোক 1 নং আসামীৰ সৈতে বিয়া দিয়াৰ প্ৰতিশ্ৰুতি দি মোক থানালৈ নি 1 নং আসামীক মুকলাই আনি মানে accused number 1 he was my lord apprehended by lord police my lord on the basis of the complaint my lord. And the allegation is that this accused person my lord called the victim my lord and he was released from the police my lord by negotiating that my lord he will marry the victim my lord. It is part of my lord.
They are family members. Actually, they tried to, break that.
Yes, my lord. Thereafter, my lord, thereafter he has not married, my lord.
Lordship, his matrimonial case is pending before the learned court below, Lord. Informants. Matrimonial dispute.
So,
and he's 19 years. How he can marry, Lord?
CD with interim.
Obliged.
Heard 482 bail application. Dhubri PS case number 344 of the section.
And the CD along with a medical report.
Medical report.
Yes, Lord.
The case arose out of FIR dated, and so the date of the FIR 11/8/2025, lodged by the alleged victim woman. The gist of the allegations that the petitioner number 1 is at about 19 years, had relationship with her, the promise of marriage. And as a result of which she also contracted pregnancy and subsequently consumed medicine at his behest for abortion. It is alleged that subsequently the petitioner number 2, 3, 4, and 5, who are stated to be family members of the petitioner number 1, brought her to their house with the promise of marriage, but thereafter took her to the police station and also physically abused her. All for the case diary from the concerned police station. However, in the interim, 25,000 at once subject to the condition SL operative investigation appear for recording their statements. List on
21/1.
Deeply obliged.
21/1/2026.
26. 21. 26. 125.
May I plead your lordship? Lordship, this is a subsequent anticipatory bail application, lordship. Your lordship was on the previous occasion was pleased to reject this bail application on 7/8/2025. This is at page 52, annexure 8, your lordship.
Rahul Mishra.
Yes, sir. So Lordship may allow me to kindly read the FIR, Lordship. Lordship, there is on page 13 annexure 1, Your Lordship. I would like to bring to your kind notice that my brother Sumanto Bora is absolute owner of a land measuring 1 biga under dark number 1619, pata number 852, situated village Saukuchi under Beltola Moja under Dispur Revenue Circle, District Kamrup Metro, Assam. That on 23/2024, my brother had came to know from the staff of Circle Officer, Dispur Revenue Circle, that some miscreants have forged his signature and by impersonating him with criminal conspiracy and have sold his pata land mentioned in the schedule of his land without his knowledge. On inquiring with the help of LR staff, we have come to know that an irrevocable general power of attorney was shown to be executed by forging his signature, by impersonating and fraudulently and with criminal intent, favor one Rahul Mishra, son of late Kishore Mishra, resident of Ahumgaon, near so and so. A copy of the said irrevocable power of attorney is attached to it, marks the document number 1, Fellowship. It is also being to notice that my brother Sumanto Bora PAN number so and so has shown the power of attorney is not his PAN card number. The next page is Fellowship. That Sir Rahul Mishra, on basis of false power of attorney, sold the land measuring 2 katha 3 lesa to one Muhammad Ayush, son of late Muhammad Yunis, resident of Mahaba, Barpathar, near Little Angel School, Shillong, East Khasi Hills, Meghalaya, so and so, and Riaz Ahmad Azad, son of Abul Kalam Azad, resident of near Little Angel School, Shillong, so and so. A copy of the sale deed is annexed here with. That sir, after execution of the sale deed, the names of the purchaser have been mutated in their names in a Jamabandi as far record showed. I request your good self to register a case and inquire, investigate into the matter, verify the documents that bring the culprit involved in the process of forgery, and protect my rights of life and property. Your Lordship, very significant point to point out here, Your Lordship. On perceiving and observing the FIR, Your Lordship, it reveals that the executant Sumanto Bora had not lost the FIR, Your Lordship. It was lost by one Santanu Bora.
But see, being a subsequent
Yes, Your Lordship.
this new, what are the new grounds?
New grounds, there are multiple grounds, Your Lordship. One is,
Please take me.
yes, Your Lordship. Two is the one medical ground regarding
If
his.
necessary, we'll go back to the merits, but to some extent.
Yes, Your Lordship.
But let us see the new grounds.
New grounds, Your Lordship, that is the medical, Your Lordship. It's on page 6 and 7, Your Lordship.
Page 6,
Page 6, oh, sorry, sir. Page 39, Your Lordship, Annexure 5, Your Lordship.
page 39.
Yes, page 39, Annexure 5, Your Lordship. Your Lordship, I'm been blessed with a baby girl, Your Lordship, a minor baby child. The photograph was annexed, which is a page, Your Lordship. Annexure 7, Your Lordship, that is after page 51. Recently, Your Lordship. And regarding, there is a one ground, Your Lordship. And the other ground is that, Your Lordship, there is a medical certificate of the accused. That's me, Your Lordship. That's page 44, Your Lordship. I'm still being under treatment, Your Lordship, only because of my stage 3 fatty liver, Your Lordship, disease, which is very serious in nature, Your Lordship. The whole case relates to one documentary evidence, Your Lordship. The case is documentary evidence, and if I'm sent to custodial interrogation, Your Lordship.
When was the baby born?
Baby born, Your Lordship.
Can you have that?
Akansa Hospital, Your Lordship. Akansa Hospital.
It's okay. Just help me with the date.
Yes, Your Lordship. That is on 26, 25. 2/11/2025, Your Lordship. 2/11/2025, Your Lordship. 25.
So we'll call for the updated case.
Yes, yes, Lord.
Yes, call for the update case there and my lord regarding his ailment, my lord, Lordship may kindly
No,
come to
not
case
ailment,
number
for,
44.
so the baby, we'll give him interim first.
Your Lordship.
No, earlier, my lord, he was granted interim, my lord. Thereafter, my lord, his interim was, my lord, vacated, my
Yes,
lord,
vacated, Lord.
while rejecting this bail application, my lord.
Only for this
So,
reason.
my lord, let the case there be called for, my lord. This is from Bokisto PS, my lord. We can fix it any date, my lord, next week. Yes,
So-
next week, any date.
That can also be done. But because otherwise there are some, some materials I found actually. Yeah.
Yes, my lord.
Materials are-
After perusal of the
But
case,
it
there
can
Lordship
be
may
a-
earlier
This
rejected.
can be a humanitarian reason.
Your Lordship, a humble prayer before your Lordship.
Whoever it is,
If your Lordship may allow me.
whoever it is, let him spend some time with the infant. For EPQ bail application. Or so and so. Bokisto PS case number 151 of 20. It's fairly submitted that an earlier bail petition was rejected by this court on 7/8/2025 in AB 1053 of 2025. Full stop. After perusal of case there. By way of subsequent grounds, it is stated and submitted by the petitioner side that on 2/11/2025, the petitioner, accused petitioner and his wife were blessed with a baby. In the meantime, investigation might have been completed also. Lot of time. It was rejected in August. Call for the updated case diary from the concerned police station. However, in view of the
So the
birth of
question
the
is that when the baby born.
2/11, he says.
No, 2/11, my lord, this is the investigation report, my lord. Lordship may kindly say, my lord, page number 39. This is my lord, investigation Doppler of pregnancy. my
Otherwise,
lord.
if it was taken up in the earlier bail petition, then it would not come. It would not be a subsequent ground. But I don't remember. This is a
So
photo
there
of
has to be, my lord,
this
some
photo-
materials, my lord.
This is a photo of a newborn, born on 2/11.
Yes, Your Lordship.
I believe you. Should be council.
So kindly, I may peruse the birth certificate on next, Your Lord. That may maybe make clear.
As per his, let's write later. It is submitted by the learned counsel that as per his instructions, the baby was born on 2/11/2003. Call for the case diary. However, in view of the birth of the child and on humanitarian considerations, it is directed that in the interim, in the event of it, 25,000 at once. His statement probably has not been recorded. Most probably.
No, my lord, earlier while he was on interim, his statement recorded. my lord.
recorded.
Your Lordship.
That is reflected from this, my lord, other rejection order. my
Cooperate
lord.
with, I've seen, cooperate with the remaining investigation. Then he shall appear before the IO once again and make himself available for examination, further examination if any. He shall not hamper or tamper with it. He shall not abscond.
Your Lordship, pardon me for humble prayer, Your Lordship. I may record the interim protection, Your Lordship, because I'm in out of Assam, Your Lordship, because of my fatty liver. So kindly take collect the case diary only, Your Lordship.
No, I did not understand.
Actually, Your Lordship, as per instruction, Your Lordship, interim protection may be not required at this stage, Your Lordship, because already I am under treatment, Your Lordship.
Very good, my lord, he does not want interim protection.
No, but he doesn't want to be with the baby. That's what I thought. He'll like to spend some time with the baby. I can,
If this is the submission of the petitioner, my lord, that he does not want interim, my lord.
Already,
sometimes, no issue.
and more interesting fact, Your Lordship, if Your Lordship may allow me, Your Lordship, the FIR lodged by the police authorities are under relevant sections of IPC, Your Lordship. If Your Lordship may see.
He stays outside Assam.
No, not outside Assam. He is in Rangia, Your Lordship. But
Rangia?
now, yes, now he is in Hyderabad only because of his medical condition, Your Lord.
AIG.
Only medical condition, Your Lord.
No, I will
He
not
may
say
go
this.
undergo surgery also.
I
His
don't want to-
submission may be recorded, my lord, that he does not want interim
No, no.
protection, my lord.
Yeah, even then I can give.
Okay, Your Lordship.
Yeah, I don't want to backtrack. Let be, but
Okay,
appearance to
Your
nullify.
Lordship may give.
He'll continue, he'll render cooperation with remaining investigation and shall not hamper or tamper with it.
Yes, Your Lordship.
For the baby.
It may be kept.
Only for the baby.
Okay, it may be kept.
My lord, from 28/1, my lord.
28th one.
28/1.
Then I thought we'll give it earlier.
No, earlier, my lord, CD may not come, my lord.
CD
That
may
is
not
the-
come.
and
Investigation must be complete. 28, it was in August
Then,
only.
then, my lord, 9/1, my lord.
No, you suggested 28-1.
28/1/2026.
You suggested.
Yes, my lord. Yes. And my objection may be recorded, my lord, in the interim protection.
The learned additional people objects to the prayer for interim bill, submitting that the earlier pre-arrest bail application was rejected after perusal of case diary.
My lord.
28-1.
I'll get it.
Timing at 14.
Where? My lord, allegation of my lord taking a truck, my lord, to carry my lord vegetable for Arunachal, my lord. FIR is page 8, my lord. and it was not, the vehicle was not returned, and the accused did not respond on telephonic call, my lord. But my lord, so many sections inserted, my lord. The 314 bracket 4, 317 bracket 4, 316 bracket 2. My lord, this section, my lord, ingredients of this section 317, 3162 are not there. Kindly see, my lord, this FIR, my lord. It may be a case of, my lord, a criminal breach of trust. Page 8, my lord.
Criminal breach of trust, and if the allegations are true and in very, in serious conditions.
Yes,
The
my
allegations.
lord, taking vehicle and my lord not returning a.
Case diary may be called for, my lord.
Yes, definitely.
And my lord, 64 days in custody, my lord. And my lord, if ingredients of 317 is not
This is a
there, my
90-day
lord,
offense, right?
statutory, my lord,
90-day offense.
my lord, 90 days, but my lord, this ingredient is not there.
No, interim would not be justified.
The case diary call for.
Call for the case diary of Heard S. Joe. Rota PS case number 95 of Philly. This is the matter on
1812.
My lord, 18, my lord, it
18,
may be
12.
16, my lord. 18, my lord, the last.
How about on after vacation?
After vacation, my lord, take money.
My lord, 64 days in custody,
Okay.
and my lord,
It's a BA.
GA, my lord. So
BA.
18 1, my lord. 1812, 1812.
Lordship, the matter may be passed over for the time being.
Thirty-three also timing, my senior is coming. Says both. After some. Deep level.
May please your lordship, the accused petitioner is behind the bar, lordship, 56 days. But 60 days is remain equity period, lordship. Length of detention, lordship, the consider the bail application and the petitioner is the not paid, named accused, lord. Only for suspicion, there he was arrested. 56.
Carriers come.
Case they receive, my lord.
56 days, no recovery, lordship, from my possession. Length of detention, lordship.
My lord, here is they receive, my lord.
Dacoity.
Yes,
Robbery.
robbery, my lord. Theft of.
17.5 dollars of gold.
Yes,
supposed
yes.
to be stolen. along
Here
with
one, the
50,000.
present accused person, and thereafter, my lord, on the basis of his statement, one Rakesh Kormokar, he is the purchaser of my lord, on the basis of the suspicion that he has purchased those, my lord, golds. He was also arrested, my lord. And from the possession of my lord Rakesh Kormokar, my lord, one melted piece of gold
Mhm.
weighing approximately 6.8 gram, my lord, recovered, my lord, from Rakesh Kormokar. And initially, my lord, on the basis of the statement of the house owner, here incident occurred between 5:30 to 10:30 p.m.
At night.
At night, my lord. And at that point of time,
House
when
breaking by night.
at night. And at that point of time, at 10:30, while the house owner, my lord, reached his residence, then, my lord, one of the accused, the present petitioner, my lord, my lord, fled away from the spot, my lord, while his, my lord, however, house owner, my lord, could be able to, my lord, record
Yes,
the,
yes, I'm right.
my lord, registration number of the motorcycle used by the present petitioner. and on the basis of his statement, the present petitioner was arrested. And against the present petitioner, earlier other 3 cases pending, my lord. Gubardhana PS case 6724, Manikpur and Abhayapuri.
Heard.
And one
Length
other
of-
accused, Ilyas Ali, not yet arrested. my lord.
Length of detention, Lord. It's a secret.
483 bail application. Sorbog PS case number 96 of 25, and so he was arrested on 14/10/2025 during investigation. The allegations in the FIR is that during the absence of the informant in the evening/night hours, miscreants broke into his house and committed theft of 17.5 tolas of gold and cash of rupees 15,000. Good stuff. The case diary has been received. The learned additional PP submits that besides investigation materials lending support to the allegations about involvement of the present accused persons, there are also 3 more cases pending against him pertaining to similar illegal activities. Full stop. The stolen materials are stated to be not yet recovered. Full stop. Investigation is not yet completed. In the given facts and circumstances, despite the length of under trial detention, the bail petition stands rejected at this stage, returned by the case there. It's yours, same.
The shown arrest case, Lordship,
In this case, my lord, case diary not yet received, my lord, 35.
the Lordship, in this case, Lordship,
He was shown arrested on the same day, right?
same Lordship, same against the no 47, notice was sharp 48, Lordship.
Get the case diary.
Yes.
Also see these aspects, right? Because these aspects are independent of merit. See these aspects also.
The Lordship, in my information, Lordship, the FR has been
Get that also.
filed.
In this case, so your lordship, kindly after time,
The petitioner was shown arrested in this case on 14/10/2025.
kindly pass over for the time being, because if FR, my lord, one of the,
Then you can approach trial court also, or we can. After some time.
after some time, my lord.
Develop. 30 seconds.
Lordship, a regular bail application, my lord, 2 petitioners before your lordship, my lord. My lord, FIR may be seen at page 8. And lordship, the vernacular portion, page 13.
The allegation.
Election regarding, my lord, trafficking of a child, my lord.
It was alleged that the informant who saw the minor girl was crying in the train station and informed the informant that train station, while they were going to Pasighat, my lord, Arunachal Pradesh. Actually, what happened, my lord, the girl who, my lord, about 18 years old, my lord, she was housemaid of the petitioners. My lord, while they were traveling to, my lord, Pasighat for petitioner number 1's sister's birthday celebration, my lord, birthday in to attend the birthday, my lord, and she doesn't want to go to Pasighat, my lord. Therefore, she was crying in the train station. And the, my lord, victim girl's parents, my lord, they themselves, my lord, engaged her in the petitioner's house as a housemaid. And it was, my lord, under impression that she is about above 18 years old, my lord, as her parents also told that, my lord.
What is there in the 183 statement?
Yes, Your Lordship, I have 168
I
statement.
have not read it.
Otherwise, my lord, see, victim has not implicated, my lord.
Not implicated.
Not implicated.
It's okay. Do I need to read? It's okay.
Yes.
Save time. Third, friends.
I'm obliged.
483 bill application. Seeking regular bail for accused Deepali Dev and Karuna Singh, who were arrested on 3/11/25 in connection with NLP GRP case number 15 of 2025. So and so section. The allegation in the FIR dated to 2/11/2025 lodged by one personnel of Government Railway Police has alleged that he saw one girl crying in the station, and upon asking her, the girl said that she was being forcefully taken to Arunachal Pradesh for selling to some person. The case diary has been received. The learned additional people. The case diary has been received where the statement of the victim girl and the 183 BNSS recorded before learned GMSC is also available. The learned additional PP, Mr. Bhattakur, fairly submits that the alleged victim girl is not implicated. In the said facts and circumstances, the petitioners are allowed to go on bail of rupees 20,000 each. Stick to the condition that they shall cooperate with remaining investigation and shall not hamper or tamper with defense. Return case that.
My lord, one aspect, my lord, I would like to, my lord, the case has been already transferred to Rangapara PS as informed, my lord. And which has been newly, my lord, registered as Rangapara PS
Yes,
case number 109.
10925 minutes.
And the appropriate
Yes,
court will be
in the
CJM Sonitpur.
In the meantime, the case was transferred to Rangapada PS and re-registered as Rangapada PS case number
109/2020.
109 of 2025. Case diary is of Rangapada.
Rangapura PS 109.
The case diary subject concerned learned court within bracket CJM Sonitpur.
My lord. Highly obliged.
It will be play. This trigger. Take a shot.
My lord, yes, 35, I have received the instruction, my lord. In this case, final report submitted, my lord.
Final report.
Final.
No charge sheet.
No such statement. Final, this is the, your lordship.
He may be released.
This can be. But he will not be able to get released because it's rejected in. Anyway. Invoking 483, the petitioner had sought bail in connection with Thorbok PS case number 101 of 25, in which he was shown arrested on 14/10/2020. Learned additional PP, Mr. Bhattakur, submit that upon completion of investigation, final form has been submitted in the by way of the final report, right? FR number 8 dated 30/10/2020. In view of the same, in the instant case, the accused is allowed to go on bail of rupees. This he can be allowed on personal bond also.
Yes.
Allowed to go on a personal bond of this 5,000 with the satisfaction of the concerned learned court, subject to the condition that he shall cooperate with the process of law. This can be kept here.
Yes, ma'am. That may be kept as part of.
This will be kept in the record.
Diploma.
Please, Your Lordship. Lordship, this is regular bail application, Lordship, and there are some altercation took place between two groups, Lordship. And subsequently, two FIR has been lost by Lordship, and first FIR, Lordship, will find page number 16 against us, Lordship. And they implicating there are 19 numbers of accused in the FIR, Lordship. And operating person start from page number 17. May I read, Lordship? There's nothing, no. There's Just scapulies took place, Lordship, and regarding the
January.
land, Lordship.
They were arrested.
Lordship, I am in custody, and the petitioner number 1 is a 70 years old person, Lordship. And some, I have annexed some medical paper also. And in this case,
And,
document.
Azmol.
And so kindly come to page number 23.
Jainuddin, no?
Lordship, page number 26 is the medical, and he's aged about
Okay.
70 years old person.
He's accused number 2 in the FIR, and the other one is, I'm just going, before
Lordship.
going ahead. Azmal Hawk in
Azmal is a son of the petition number 1, Lordship.
They are father and son.
Father and
Okay,
son.
here it is written as Azmal Ali. Anyway, you'd respect last or two. Anyways. Land dispute.
Lordship. And Lordship, and I have also annexed one. We have got the injured Lordship page number, Lordship, and it will come page number 28, Lordship. They assaulted Lordship, us, Lordship, and they are the group, Lordship, and FIR itself is very clear. The contents of the informant FIR, Lordship. Okay.
Yes, that is come.
My lord, case that you have received, my lord, and my lord, as part of statement of the victim and other witnesses, my lord, the incident of duty, my lord, boundary dispute, my lord.
Boundaries.
And my lord, allegation is that they have assaulted, my lord. And I have also perused the, my lord, injury report, my
Yes.
lord. Injury reports are, my lord, simple, caused by blood weapon, my lord. All the injury report.
In any case, this one is a little older. Now both can be allowed. (483) bail application. Sualkusi River PS case number 62 of 25. They were both the petitioners, who are stated to be father and son respectively, were arrested on 12/11/25. In this case, rising out of the FIR dated 10/11/25, in which as many as 19 persons are named. And the allegation, the gist of the allegations that the accused persons assaulted the victims after altercation due to boundary dispute. The case diary has been received. The learned additional PP, Mr. Borua, RJ Borua, submits that the dispute indeed arose out of the land matters prima facie, and that as per the injury report, the injuries are stated to be simple, caused by blunt object. In any case, petitioner number 1 is also stated to be aged 70 years. Full stop. In the circumstances, both the accused persons allowed to go on below 25,000 each. The surety of the like amount each to the satisfaction of concerned learned court. This will be
Judicial Magistrate First Class Hazul.
Hajo, JMFC Hajo, subject to the condition that they shall not hamper or tamper with evidence, and they shall not misuse their liberty to commit any or illegal activity. Violation will.
Deeply obliging.
Read on case there. They were arrested in September itself.
Yes,
Okay, ma'am.
Lordship. And today speaks for obtaining instruction by the learned PP, Lordship, whether such sheet has been filed or not.
The investigation is pending, my lord. We have not received the case diary.
Post 90 days is over. Almost. What is the allegation? Death is there.
Lordship,
What is that?
elevation under section 329(3), 118(2), and 109, attempt to murder. Today is 88 days, Lordship.
Is the FIR name accused person, my lord?
Yes, that's true. So again, we should remind of the case that
Lordship, today is 88 days. Lordship.
Not to fix the day after tomorrow, my lord. Not the Friday, my lord. Friday, he will complete 91 days.
Then
Thursday
Lordship,
also we can fix it.
then Lordship, I may be allowed to withdraw the petition, Lordship. You will get default bail on day after tomorrow, Lordship.
Can you take instructions? More.
No, search is pending, my lord. The investigation is pending, my lord.
Investigation
Can
is
at the best,
not yet completed.
not yet completed. Can at the best call for the case.
After
then.
2 days, he can approach the magistrate court also. What would you prefer? Withdraw?
Withdrawal.
Withdraw. Because we don't have any materials, right, at this stage, this medical report or whatever. But he has survived, no? He's not dead.
That is, my lord, we are not.
That also we
go
don't.
to the case there.
Anyway. Case diary is not received. However, at this stage, the learned counsel for the petitioner seeks permission to withdraw this petition. The prayer is allowed. It's post of withdraw.
Public.
Yeah. Yeah.
58 month is better was this that yesterday, my lord.
Yes.
60 days today.
And my lord, it's in this case, Sarshid has been submitted, my lord, on 24/11/2025.
24/11.
Sometimes
no
this
time.
file date is comes, it takes some time to come into the record. Would you approach the trial court then?
My lord, once the High Court rejects, normally trial courts are averse from granting bail because it's a second bail application. That is what experience says, my
High
lord.
Court is not rejected. It's
Yes,
a
it
second
was-
application.
No. The first application was rejected. Once High Court rejects a bail.
Oh, then it will not be possible
lower
unless it
court-
is unless it is a statutory bail or something.
Yeah, because
Then they will hesitate.
lower court.
That's true. Subsequent.
My lord, can it be taken up after, my lord, after a couple of items? My lord, I'll take telephonic instruction whether they want to approach lower court or not. After a couple of items.
No, it will be difficult actually for the court also because it is once rejected by the High Court. And not telling that to the court will be highly unfair to the court.
No, that too.
No question.
Yeah.
Because, but no question of that. And if the court comes to know, naturally they will, because sessions rejection only they hesitate. This is court is, anyway, you can take it up after some time. You talk to you.
Yeah, I'll just have some telephonic
party.
instruction as to what they want.
No issue.
CS number 61.
I'm deep.
Listen.
May I please, your lord? This is a charge-sheeted case, your lordship. The petitioner is behind bar for 1 year, 6 months, 21 days, your lordship. Your lordship, he is charged under section 302. Your lordship will kindly come to page 17. This is the FIR. your lordship.
Trial is started.
Trial started. Out of 17 witnesses, 13 witnesses has been examined, your lordship.
Is it?
Most of the witnesses are vital witnesses are examined, your lordship. Therefore, probably their further custodial detention is not at all required, your lordship. Page 17 is the FIR. With due respect, I beg to inform you that last on 5/5/2024, my son Hiranmoy Kaklari proceeded along with his friends to BDP Associates Pepe in the house of accused to query about the rape of the victim girl, namely Neha Hazari and Mukuta Muslim, then brother of the accused Dhan Talukdar Shekhar Ali, friends of Dhan Talukdar Bahar Ali Rahman, beaten badly with lathi. At the same time, sister Dhan Talukdar, namely Purnima, had attacked Hiranmoy backside with a dagger. As a result, he got sustained injury inflicted on lung. As per doctor advice, better treatment. He was admitted at GMCH, regretted on 16/5/2024. He died. This was lodged on 17/5. Date of occurrence is 5/5/2024, your lordship.
There was some rape incident or something.
Yes, your lordship. What has happened, your lordship? There is a rape, allegation of rape, your lordship. That trial is also going on, your lordship. Against your lordship, these petitioners, your lordship. And they are in custody in that case also, your lordship. Now, your lordship, so far as the present case is concerned, your lordship, it is the after effect of that incident, your lordship. Some people went to protest at their home, your lordship, as reflected from the FIR itself, your lordship. And then your lordship,
They were assaulted.
they were assaulted and according to them. And in fact, there is a counter FIR also, which your lordship will find at page 49. This is by the
Prosecution.
petitioner side, your lordship. Now, now your lordship, I am not on that merit, your lordship. Since your lordship charge sheet has been submitted, trial is going on, he is participating, your lordship, 13 witnesses are examined. And therefore, your lordship, probably further custodial detention of the petitioner is not required. The length of detention probably is a ground in my humble submission for releasing this petitioner on bail. And secondly, your lordship, I have also taken a technical ground that your lordship, when these petitioners were arrested, the grounds of arrest were not furnished to them, your lordship. That is the second ground we have taken. And as your lordship knows, your lordship, even if since it has its genesis, the right has genesis in Article 21, fundamental right, your lordship, then your lordship, even if at that stage it has not been complied, that right cannot be waived, your lordship, and I can claim the benefit of that at any stage of the proceeding, your lordship, till trial is completed, your lordship. These are the two grounds, your lordship.
And first we have to, anyway, trial has progressed, but we
Yes,
have to
my
see
lord.
the ground.
Also,
Otherwise, the matter is a serious matter.
Yes, but out of the 7 witnesses, my lord, my learned pen has already submitted, my lord.
13 witnesses.
13 witnesses have already been examined, my lord. And I have perused the scan copy, my lord. Most of the witnesses are implicated, my lord. There are even eyewitnesses, my lord. So, my lord, since it is a charge-sheet case, my lord, trial is going on. So, lordship will have to consider their bail application only on merit, my lord. But lordship cannot, my lord, give any opinion, my lord, while granting or rejecting, because either way, my lord, it will hamper the investigation or the trial and as well as the my lord accused person. Now, as far as my lord, the grounds are concerned, my lord, that I maybe allow some time, my lord, whether the notice has been served or not, my lord. Otherwise, as far as the materials are concerned, my lord, there are sufficient materials.
Also a ground,
Lord,
but depends on the
that's and
seriousness
secondly,
of the
your
matters.
lordship, ultimately, your lordship, it is a question of bail, your lordship. Now, on merit, your lordship, what will happen in trial, it will happen, your lordship. Unless there is a sufficient cause for denying the bail, your lordship, like that he is a flight risk, your lordship, or your lordship, there is a possibility of tampering with the evidences, your lordship, witnesses, your lordship. That if those are not absent, your lordship, probably your lordship can, in my humble submission, your lordship, consider the case of the petitioner, lordship. And rest of the witnesses are all official witnesses, your lordship.
After some time, Purva?
That will be after some time. I'll go to the.
Lordship.
Take your time, no.
Lordship. Deeply obliged.
Well, I have taken instruction, they would prefer to approach the trial court. The case was not of that heinous nature also. The 3 years, the total length of
But
imprisonment.
bring this to the notice of the court also, that it was earlier rejected on merit.
I'll send it back, Nabri. It is in Dhubri.
They send it back because otherwise, the affidavit is there. The courts, learned courts below always refer to the affidavit. Yes, you are appearing for the informant in this.
Yes, yes, sir.
Make your submission.
Your lordship, my objection may be recorded.
No, he's in a way withdrawing the petition. He wants to approach the learned court. So, but I'll record. Third M. Biswas Learned Council, additional PP RJ Purva, and your good name, please.
The law.
Perfect. Learned Council for the informed. Is subsequent bill application as an earlier bill petition was rejected by this court by the order dated so and so in order dated 24/11/25 in BA 3464 of 2020. The learned additional PP submits that in the meantime the case has been charge sheeted upon completion of investigation.
By charge sheet number, my lord.
Right CS number.
61/2025 dated 24/11/2020.
The learned counsel for the informant submits that the informant has objection to grant of bail. However, in view of the completion of investigation, the learned petitioner counsel, Mr. Biswas,
They are going to the paper.
submits that he may be allowed to approach the learned court below, learned trial court, for bail. Allowing the prayer, the instant bail petition is disposed of, and the petitioner is given the liberty to approach the learned court below for regular bail in view of the completion of investigation. Bail petition stands disposed.
I'm obliged.
Page hearing 38.
In this case, my lord, up to the city was called for, my lord. That is not received, my lord. Earlier we received the case diary, my lord.
Yes. Case diary, up-to-date case diary, it's not yet received. Issue reminder for the same. The interim bail granted by the order dated long time.
10 to 2025.
Up-to-date. It had come once.
It has come once, my lord, but it
So
was
we
sent for update.
sent it back. Order dated 10/2,
Yes, my lord.
long
10 to 2025.
10 to 2025. It will be 1 year. Not good. We should when should we have it? Before vacation?
My lord, before vacation, it may not come, my lord. It will be immediately after vacation, my lord. 8 or 9 months.
Because that direction. is
Yes,
there.
my lord, yes, lord. To be absolutely correct.
Release the matter on 6/1,
My lord.
2020.
My Mr.
Interim bail.
My senior Mr. P.K. Mahagani is on the way. Just for after.
In this case, charges submitted, my lord.
Shall we wait?
Wait.
Just one.
Here in this case, FIR, your lordship, will get at page 17. Main
Case diary is
allegation-
not received, my lord. He is on interim, my lord.
No,
He had waited, my lord. Some
so
time
here
ago.
lordship just replacing few facts. lordship.
You want to say something?
Yes, here allegation is that lordship some betel nuts were recovered while loading, while it was loading in a truck, lordship. And then FIR was lost. Vehicle was seized and those betel nuts were seized. Now the owner of the betel nuts and the present petitioner approached before this honorable court. Both were granted interim. The other lordship, that owner of the betel nut, he is granted absolute bail by this honorable court. And now to my information, so already charge sheet is submitted, so he is already interim or he is on interim bail. Whereas the person who is the owner of the betel nut, he is granted bail. So by keeping him, the no fruitful purpose will be served. So he may be, bail may be granted, he will appear before the trial court, lordship. That a copy of filing charge sheet, lordship, that I have detailed, was the details from e-court that I am handing over to your lordship. And the copy of the order granting bail to the owner, lordship.
This is about, PRC.
PRC number that, and next date is now, lordship, on 11 to 2026. So he will appear prior to that or on that day, whatever your lordship directs. lordship. PRC case number. Yes. Sports.
So can you confirm, he must be right?
But that if my learned friend whatever submitted, my lord, is on record, my lord. My lord, the charted has already been submitted and my lord, someone has already been.
Yes, he will appear.
Let him appear, my lord, and he extended maybe extended only till his appearance.
They'll no, I'll dispose it of, but the thing is that they will have to submit press bail.
Yes,
You will submit.
You want to, you want to take instruction regarding completion?
But for that purpose, my lord, we have to obtain the certificate number, my lord, whether certificate is submitted.
Dispose it of.
Lord.
Our 17.9. Is that para 1, 2, 3. The petitioner was granted interim bail on. Oh, there's a earlier order.
12/8/25.
12/8/2025. 12/8/2025. This submit, Mr. Ahmed, Learned Counsel submits that one co-accused Munna Aziz has already been granted anticipatory bail by this court by the order dated 17/9/25 in AB 1924 of 25. It is also submitted that in the meantime, you are sure about lordship. In the meantime, the case has been charged sheeted. He has definite information that in the meantime, the case has been charge sheeted upon completion of investigation. Third, learned additional people, RJ Bose. In view of the completion of investigation and also bail to co-accused, the interim bail rights also is hereby made absolute, subject to the condition that he shall be available for trial if one commences against it. He shall not hamper or tamper with evidence. And shall not commit any illegal activities. Violation in petition stands out and disposed of. You want this back? Take it.
Lordship, I keep it as a part of the record because I have
This-
submitted, yes. Oblige, Lordship.
What is my charges submitted?
Lordship, I'm on interim.
Interim order.
Yes, Lordship. 15 days time will be given, Lordship.
New provision, the new provision. is-
Yes.
Order set. Your Miss Singh, J, you
J.
could.
Singh.
Yeah. Heard. RJ Purba. 18/9/2024. Second, third paragraph is same. Stop. It is submitted by the learned additional PP, Mr. Borwa, RJ Borwa, that in the meantime,
My charge sheet has been submitted, my
has
lord,
been
by
submitted.
charge sheet number 195/2025, dated 28/9/2025.
in view of the completion of investigation, the interim bail granted by so and so is hereby made absolute. Subject same. Okay. The bail petition is allowed and disposed of. Of course. Your man. Spend.
Here in this case, FIR Lordship will get at page 10, Lordship. Here allegation is that Lordship, one vehicle carrying some betel nuts were coming and in the highway that was looted by some miscreants, Lordship. Now here in this case, Lordship, in the FIR, no names are mentioned, but my role, Lordship, may kindly see at CJR list that your Lordship will get page 16. Annexure 2. Page 16. Lordship, go.
Yes. Page 16. Name is?
I, SI so-and-so have hereby seized the following descriptive articles from the possession of Syamal Mitra. So Syamal Mitra is the petitioner before your Lordship. Now here I am, Lordship, that some quantities were recovered. Now how this is recovered and on what on the information of given by whom, that your Lordship will get at page 18. Because I am the person who informed police that I have purchased these articles from so-and-so and I suspect that these are stolen articles. So accordingly, they made inquiry. Page 18, Lordship may kindly see. On 2/1/2025, the IC of Kukurkata OP informed me by Kukurkata OP GD number so-and-so dated over mobile phone that one Syamal Mitra, that is the petitioner of Krishna, had reported at the OP that 6,300 kg of Supari betel nut had been brought from Najimuddin of Beltarghar. Syamal Mitra had lost the information at the OP due to suspicion regarding the activities and conduct of Najimuddin.
This is reflected in the interim order also.
Yes.
Given this petitioner, your petitioner is also charged sheet.
Yes, he is charged sheet. Only apprehension your Lordship will see in the charge sheet, just I am showing before your Lordship. In the charge sheet, page 32.
Yes.
That he was not arrested during investigation, Lordship, although that those down below your Lordship will get date of arrest nil, page 32.
Yes.
Not arrested because although those articles were recovered, but he informed, therefore he was not arrested. Now page 57 is the cognizance order, Lordship. That against me charge sheet was submitted for purchasing those articles, stolen articles. That was the allegation in the charge sheet. But in the charge sheet, in last portion, Lordship, that court took cognizance against all the accused person under section 3173 also. So therefore, the present petitioner is apprehending that if he goes there, because this is a sessions triable case, he will be apprehended. He will be taken into custody, Lordship. Only because of the otherwise, he will face the trial if anything is there. And in fact, this is what I find, Lordship, subject to correction, that this is a case for crossing. In fact, he informed the police. He helped the investigation.
Anyway.
This is a search case, my lord. I have perused the scan copy of the record, my lord. And from the scan copy, my lord, it shows, my lord, that, my lord, this accused person, my lord, he brought 98 bags of areca nut, my lord.
From him.
Amount into, my lord, 5,500 kg. From one Rohit Batsa, my lord.
Not Najimuddin.
No, Rohit Batsa. That is, my lord, as per his statement, my lord. Then, my lord, thereafter, my lord, this areca nut it was seized, my lord, and he was given, my lord, 35T notice, my lord. 35T notice, my lord, and he was never, my lord, wanted, my lord, while the investigation was going on, my lord. So now, my lord, he is on interim, my lord. Since the search has already been filed, my lord, so direction, so my lord, Lordship may pass an order, my lord, that his interim may be extended till his appearance.
Just I am placing one order.
During investigation, my lord, police has not sought for any his for custody interrogation.
Yes, my learned friend has
This cannot be
pointed
kept
out.
pending, right? This cannot be kept pending. This has to be disposed of.
Disposed of.
Well, our learned friend has rightly pointed out that during investigation, his custody was not sought for, Lordship, and therefore, Lordship, this order, Lordship, may kindly see Supreme Court. Paragraph 2 onwards, Lordship. It appears from the materials on record that a first information report has to be come to be lodged at the Kotwali Police Station District, Barabanki, for the offence enumerated above. It is the case of the prosecution that the check period between 2002 and 2009 revealed that the petitioner herein had assets disproportionate to the tune of rupees so to the known source of his income. In such circumstances, the Anti-Corruption Department, Ayodhya Faziabad, UP decided to proceed against the petitioner. We have heard so. This part paragraph I'm skipping. Paragraph 5, Lordship may I say. We take notice of the fact that the investigation is over and the charge sheet has been filed in the CBI court at Gorakhpur. While the investigation was in progress, the investigating officer did not deem it fit to arrest the petitioner therein. The CBI court has taken cognizance and has issued summon to the petitioner herein to appear. The learned counsel appearing for the petitioner would submit that there is a practice in the state of Uttar Pradesh that arrest is effected after the charge sheet is filed and the court takes. We do not propose to say anything as regards in this usual practice except that it makes no sense. We are of the view that once the investigation is over and the charge sheet is filed, then the accused should be asked to appear before the court concerned and should furnish bail to the satisfaction of the trial court. If at all the investigating officer wanted to interrogate the petitioner, he could have arrested him during the course of the investigation itself. Now there is no point in making a formal arrest. In such circumstances referred to above, we order that petitioner herein shall appear before the court so and furnish bail to the satisfaction of the.
Unless he has remained evasive or something and
Yes.
custodial interrogation is necessary for some further investigation. But in this case,
But says, my lord, he has given, my lord, 35 notice during investigation. Now, after that, my lord, from the record, my lord, it shows, my lord, he has cooperated, my lord. And police is also knows, my lord, sought for his custodial interrogation, my lord. So, my lord, my humble submission, my lord, his interim may be extended till his appearance.
so, yeah, that is what I wanted to say. So the thing is, what is that judgment? Because this time limit of anticipatory bail, what is this last leading case of this thing? Anticipatory bail, last leading case. So that Siddharam Matre to that clarified that it doesn't have to be for a limited period. Then there's a very constitution bench.
Yes, recent one judgment is there.
My lord, next date is fixed for appearance, my lord, on 19/12. 19/12 is the next date fixed for appearance, my lord, of the petitioner and other accused.
When so? First two paragraph, 13, 11, 25. Period. 1, 2, 3. 6. 1, 2, 3, and 6. As the charge sheet has been submitted in this case, accordingly, the scan TCR was called for, and the same has been received and relevant portions perused. Full stop. The present petitioner has also been sent up for trial in the charge sheet, and the learned court below in PRC number 509 of 25 has also taken cognizance and issued summons. The next date is fixed for, stated to be fixed for on 19/12.
19/12, my lord. At order dated 9/10/2025.
In view of the completion of investigation and also the cooperation rendered by the petitioner during investigation, there is no reason to cancel the interim bail. Accordingly, the same is hereby made absolute, subject to the condition that he shall appear before the learned court will. And the next date fixed can also be available during that trial if one commences and continues against it. He shall not hamper or tamper with it. He shall not misuse his liberty to commit any illegal activities, violation with cancellation of bail. You furnished press bail bond for the learned court order.
That next date is not a 15/12/25.
15/12.
15/12.
15/12. Is it Sneha Ahuja? That's Sneha Ahuja is a leading case. I think either it is domestic violence leading case. And in that case, it has been clarified that anticipatory bail doesn't have to be for a specific period. Once it is given, it continues during the trial. But in exceptional circumstances, the court still has liberty to give it for a limited period.
That observation is also there in Sushila Agarwala's case.
Sushila Agarwal, thank you. Sushila Agarwal.
Sushila Agarwal's case. Obliged.
Disposed.
What is it?
May I please your lordship? My lord, the petitioner is a lady
and her husband is arrested in this case, my lord. And she is a housewife. So phase 9 is the affair. Let's get the ASI of Salang outpost. But in his affair, he stated that he got the information from reliable source that some illegal activity is going on in the house of the present petitioner's husband. Accordingly, my lord, a search was conducted and some article was recovered from the house. And immediately husband is arrested and taken to the custody. He is in jail, man. The phase 9 is the affair. Well, 3 printer of SP machine and 2 carton of fake Indian currency note of 500. And well, number 3, 1 bundle of printed Indian currency note. And well, 1 bundle of white printed paper and an Oppo mobile handset was recovered. Now, my lord, my humble submission, my lord, that my husband and some other person's name is mentioned here, my lord. I mean, being a lady, my lord, I am not aware if something is going on with my husband and some associate officer.
I have, also attributes something, attributes to her also, but anyway, it will depend on the investigation.
But we have received the case diary, my lord. In fact, my lord, her husband has already been arrested, my lord, and in their house, my lord, this, my lord, fake note currency, my lord, that was manufactured, my lord. With the help of, my lord, with the help of one, my lord, his name is
Cartons were found.
Bokoruddin, my lord. And his bail, my lord, previous bail has already been rejected by the honorable court, my lord. Now, my lord, there is this lady, my lord, she is the wife of the, my lord, Mujibur Rahman, my lord, and she is fully aware about the, my lord, what is happening inside her house, my lord. Even, my lord, she also helped the, my lord, the main accused person, my lord, who, my lord, used to, my lord, make all this, my lord, fake currency note, my lord. So, my lord, there are sufficient materials in this case diary, my lord.
My lord, individually, she has no any role, my lord. She is a literate lady, my lord. Let's use the thumb impression. She is not aware, my lord. Husband already arrested, my lord. Very unfortunate case, my lord. The lady, illiterate lady, she does not know, my lord, wrong, right, and what they doing in another room, my lord. So very unfortunate case, my lord. The being a lady and the housewife, my lord.
Neighbors is also implicated, my lord, because they have some sound, my lord.
Done a 482 bail application. Fake currency cases have to be investigated. That day we discussed.
This is one of the, my lord,
the
most heinous economic.
No, it will come under the schedule of NI Act, right?
Yes.
Actually, counterfeit currencies, 482. Kulsum Bibi. Uluwani case, PS case number 59 of 20. The FIR was lodged by police personnel on 30/10/2020. It is alleged that on getting information, police team searched the house of Mujibur Rahman, co-accused, and found two cartons of fake Indian currency notes, 500 denomination, along with printing machines and white paper, etc. So it's alleged that during investigation it was revealed that the said Mujibur Rahman and his wife Kulsum Bibi, within bracket the petitioner herein, along with one Bakruddin of same village and some other associates, have been indulging in this illegal activity of printing fake Indian currency notes. The learned counsel petition for the petitioner submits that the petitioner herein is the wife of main accused, and she is an illiterate lady and unaware of any such activities. The case diary has been received. The learned additional PP RJ Borra submits that the investigation has revealed materials to the contrary, and indicated the involvement of the present petitioner as well. The incriminating materials have been supported by witnesses from the neighborhood as well. Thus, it appears that from the investigation, the present petitioner is not just an innocent victim of circumstances, crime of facie. The, the circumstances, the prayer for granting prayer as bail would not be justified in my considered view. Accordingly, bail petition stands rejected. Return the case that.
Mobilize.
May please, Your Lordship. This is second anticipatory bail application. Madam. Earlier it was rejected on 24th. It has been informed me by that the up-to-date case diary is not available.
Lordship, in the earlier occasion, we have been instructed to produce the up-to-date case diary. And it is up to, the record is up to 15/09 to 2025.
Should we get it? Why not? What is the
Your
allegation?
Lordship, my lord?
Attack the police.
No, in time. FIR is at page number 18, madam. Basically, madam, what happened was that, madam, an eviction drive was carried on in Paikan Reserve Forest.
I
Wherein,
remember, it's written also.
yes, page number 18, madam. Wherein allegedly, madam, around 400-500 persons were attacking the police personnel. And the only thing is that, madam, this present petitioner happened to get shot. There is no specific allegation against the present petitioner. The only thing is that he got shot. Now, how he got shot, whether he was running away, whether he attempted to attack the police personnel, nothing has been mentioned in the FIR. Now, the thing is that, my lord, he has already suffered. He lost his house. He got shot. He was inside in the GMCH, my lord, undergoing treatment. And his statement was also recorded by the policeman. So perhaps, my lord, at this stage, after 3-4 months, my lord, custodial interrogation may not be required in this matter, my lord.
But since it has been earlier rejected once.
Yes,
so
yes,
subsequent-
madam.
So what do you do?
Lordship, since our up-to-date CD was called for before, would you kindly give us a last chance?
The case diary, the learned, Mr. S. Das, learned counsel fairly submits that an earlier bail petition was rejected by this court on 24/10/2025 in AB 2429 of 2020. Case diary as called for has been received, but it is updated only till approximately 3rd week of September 2025. The learned petitioner counsel submits that the petitioner had also suffered bullet injuries and significant time has elapsed for the investigation and perhaps his custodial detention may not be necessary at this stage. So if you send it back, when can we get it back? Because new grounds has to be, there has to be progress of
That is- that
investigation
is
or whatever,
paid.
you know.
New
It
ground
is-
has to be.
It was rejected on
24/10.
of rejection.
24/10.
24/10.
If it
So-
is possible to get it before vacation,
Right, get it. So return back the case diary and to be procured again on the next date with up-to-date, incorporating the up-to-date investigation. We can take a chance
Lord-
on 17.
Lordship, on 17.
17.
17, ma'am.
17/12.
Highly obliged. Thank you.
May I
please, Your Lordship?
Lordship will send back the.
You can send.
Okay, this matter is wrongly listed, Lordship. This matter was earlier fixed on 9th of January, Lordship. Please read the last order.
Oh,
What?
do we need to pass any order? Yeah. Sure. 9/1. Wrongly listed, wrongly listed. Next date is 9/1/26. You're right.
Obliged.
I'm sorry, my lord, I was not there on time, my lord. My lord, see, case diary was sought for, my lord, and I am on interim, my lord.
I think completion of the charge sheet. The allegation.
Well, relegation regarding, my lord, with all respect, my lord, the case was registered under POSCO Act, my lord. With all respect, my lord. Huh? Oh, CS said that charge sheet has been filed, my lord. Will appear, my lord, and not default on even on a single day.
POSCO, it's
POSCO, my lord. On each and every subsequent that we appear, my lord.
but it was not registered under POSCO. Oh, sorry.
It was registered under POSCO.
Under POSCO. So what about the this notice requirements? Notice requirements.
Lordship.
Oh, no, sorry, my lord.
Not
Cross case is
section
under
number.
POSCO, my lord. But this case is not under. I'm sorry, my lord. Mistaken, wrongly I have said, my lord.
No, sure. Otherwise, we'll have to.
Yeah,
we'll
yes,
enact
I'm
this.
sorry, my lord.
No, sure.
We case was under POSCO, my lord. Cross case.
Cross
This,
case.
this is not POSCO, my lord.
Interim is also there.
Yes, my lord. I am on interim. Yes.
Diary has been received.
Diary not received, charge sheet has been.
Charge sheet.
Yeah.
All right. I'll dispose it of them. In the backdrop of a sexual assault, there was an altercation.
Lordship.
Okay. 19/7. Second. The petitioner was, how many petitioners are there? Here?
Ma'am,
All the-
six petitioners,
All
my
the
lord.
6 petitioners were granted interim pre-arrest bail by this court by the order dated 19/7/2025. S.H. Bora, the learned additional authority, summarizes that in the meantime, upon completion of investigation, the case has been charged sheet. In view of the completion of investigation, the interim bail is hereby made absolute, subject to the condition that the petitioners shall be available for trial and shall appear before the learned court below and trial court regularly. They shall not hamper or tamper with evidence, and they shall not commit any illegal activities.
Well,
Bail
highly obliged.
stands disposed.
Highly obliged, man. Obliged. Obliged.
Note down the search sheet number, Lordship.
CS number.
CS 201/225 dated 17/08/2020.
Obliged, man.
May I finish, Lordship? Lordship, item number 59 and 60 out of same affair, Lordship. 59 and 60 out of same affair, Lordship, maybe taken together. Now, Lordship, FIR plus 16, Lordship.
Is there
CD received.
receipt?
FIR 6, case 16, 1/6.
Both are AP.
Yes, well, yesterday your lordship was pleased to read the petitioner, my lord. Here will
Oh, the fixed it.
DA, my lord.
Both are AB.
Both cases yesterday listed as unlisted, my lord. And today again, my lord.
FIR is at 9.
16, 1/6, Lordship. And petition item number 59 filed by accused number 3, 5 and 7, and 60 filed by accused number 2, FIR number 2. Accused number 1, Zohrul Islam, was arrested, Lordship, and some article was seized. Everything was seized from his possession, Lordship. Nothing has been seized from this petitioner, Lordship.
You need some time to go through it.
I have gone through the CD, my lord. Because, my lord, the allegation is that they are involved in my lord, preparing to commit highway dacoity.
Yes.
Here, although this, the present,
One
all the
person
peti-
that not one,
Walkie
one of
talkie.
these persons. One
walkie-talkie and my lord, police uniforms.
here there are. Just a minute. Let me write down the names. It will be helpful. Bongaigaon PS, right?
Yes, sir, Bongaigaon PS.
290. Okay. Ziaur Rahman, Abdul Manan, Kasuruddin, Anwar Hussain. are the
Kasuruddin and Anwar
petitioners
Hussain.
in both
Anwar
the
Hussain.
bench.
All are FIR named accused, my lord.
Let us go back to the FIR ones, as he has said.
Page 16, Lordship.
Page 16.
Yes, may I read?
Type copy.
Mannaf Ali is also known as Abdul Mannan, my lord. Abdul Mannan alias Mannaf. Petition, my lord, he has filed petition as my lord Abdul Mannan.
Eight persons were named in the FIR.
Yes,
Out of which Jaharul Islam was arrested.
Jarul Islam arrested. Yesterday, your lordship was pleased to visit the bail.
Caesar list, Lordship, page 17, Lordship. And all the articles were seized from the possession of the Zahrul
The
Islam.
type of offense regarding preparing to commit
But nothing-
dacoity in highway, it cannot be possible for a single person to commit this type of
Logically.
offenses, my lord. This is a group, my lord, larger, my lord, coordinated criminal network, my lord.
Abdul Manan is also Manaf Al.
Yes, ma'am. Here in the petition, here specifically stated Abdul Mannan alias Mannaf.
So investigation, what is the diary?
Investigation is
about
going
these
on.
persons?
Police is searching for the present petitioners, my lord. Police also in fact visited house of the present petitioners, my lord. Some
What are the materials police has found regarding them?
police initially, my lord, on the basis of that GD entry, my lord. And
Initially suspicion.
thereafter, my lord, his statement of the accused Zahrul Islam also is there. Zahrul Islam also, my lord, stated that he earlier also he is involved in committing this type of offences, my lord, along with all these accused persons. And one of the statement of the villagers, my lord, that is important, my lord, where he stated that, my lord, লগতে তেওঁ আমাৰ আৰু বহুতো ডেকৈতি কাৰ্য সংঘটিত কৰিছে, কিন্তু তেওঁ গাঁৱৰ মানুহক দাবী ধমকি ধনৰ বলত মানুহক পুলিচৰ কাষত যোৱাত কাষ চপাত অসফল হয়. That is one of the statement of the, my lord,
Against whom? Whom?
against, my lord,
Zahrul Islam.
Zahrul Islam. Zahrul Islam, my lord. Along with some other persons.
Yes, yes. It's a serious matter, but I can also have a look.
Yes,
if you want.
But Lordship, my humble submission
Yes.
is
You're for in both the cases, you are the petitioner.
yes.
You make your submissions. Complete your submission.
Lordship, nothing has been recovered from the present petitioner, Lordship. And out of gas, Lordship, the Zahrul Islam has implicated the present petitioner, Lordship. And their presence was not there, Lordship. Police not found their presence, Lordship, and nothing recovered from the house of the present petitioner, Lordship. All the things were recovered from the house of the Zahrul Islam, Lordship. So, Lordship, mere suspicion may not be ground for rejection.
At the
That
stage
is
of-
why I asked what are the other materials.
Other materials, well, the accused person stated their names. But that is at it because investigation
one.
is going on.
Villagers.
Yes. And regarding, well, GD entry is also there that he along with other
Electronic evidence is very important in this case.
Yes, electronic, regarding that aspect, my lord, there is,
Location.
till now, my lord, there is nothing. Very
You submit it, I'll have a look. Okay?
Yes.
Hopeless.
After lunch, you want to say something?
May I please,
We'll
your,
pass the-
may I please, your lordship? In item number 51, lordship, my senior Mr. D. Talukdar has busy in another matter, lordship. Kindly adjourn for the day, lordship. Item number 51. Other party, yeah, lordship.
After vacation.
After lordship, date may be fixed, lordship, in January.
January?
Lordship.
January 22nd also, it will. January 22nd, it will be better.
Let us. January 22nd is a Thursday. 22/1.
Lordship,
26.
interim order is there.
Interim order stands extended till the next date of this.
Obliged.
Wait, please, your lordship. Lordship, item number 30. Can you pass over this matter only for the day, lordship?
What is it?
Item number 30, lordship.
Admission.
Admission matter.
Admission. Okay, I'll do admission now. You don't want to do it today? Adjourn for the day. When should I, after vacation?
Before vacation.
Before vacation. Before vacation will be a little tight. Immediately after reopening. Immediately. 6/1. Any interim order? 6/1/2020.
My lord, I have a similar prayer. 49, my lord, all the couples. Here, Mr. A.K. Purukes is there. He is suffering from teeth pain. So
49.
49. So accommodation for today or after vacation, as your lordship, please.
Top of the list. I don't know why it was fixed. It was fixed on top of the list.
Yes, that is why, my lord.
Otherwise, my lord, probably in this case, final report.
Final
was
report is
submitted.
there.
The prayer then. List after vacation.
Yeah.
In the month of January.
Month.
On a date to be fixed by the registry. 53, we have to see. I may not be able to take up this matter. We'll have to look inside. Because I might have passed some order at CBI judge at that time. We'll have to look inside. Yes, same person. In that case, we'll make an order. Look into it. Please sit. I'm passing.
Thirty
33 is done. No,
32. May I please, your lordship? Lordship, in this case, lordship, other co-accusers are allowed to go on bail, lordship, on the ground of 47, 48, lordship. And lordship, the present petitioner is behind the bar as on today, lordship, 437.
This is the bail application seeking parity with that Chakadul Haq matter.
Yes, Sakidul Haq, lordship. And other two accused, Noor Safi and Asim, also granted bail, lordship. And they are the prime accused from their.
You have annexed some orders, no?
Yes.
This Chakadul Haq, I'll come to you.
Lordship.
This I have found. Others also you have annexed. No.
I have given, I have produced, lordship.
Give me one of subsequent ones.
Yes, lord.
Subsequent ones. Update what the last order.
It is. This order for lordship, Noor Safi and Asim, lordship. From their possession, actually, the contraband was seized, lordship, as per allegation.
PCR has come.
Lordship, it is there. I have flag mark lordship 47 notice arrest memo.
Same only, I think. Trial is going on, otherwise. Trial is going on.
Lordship, trial is going on. Charges are yet to be framed.
Lordship,
Oh no, then trial is not started.
lordship, as per my knowledge, lordship, one accused, absconder charge sheet was filed, lordship, and NBW was issued. Perhaps NBW is pending, and therefore the trial was not proceeding. All total, lordship, there were 5 against 5 accused persons. The final complaint was filed, and among them, one was shown as absconder.
Ultimately, it has to be split.
Yeah.
Memo of arrest, it narrates some details. But 47 is, of course,
Yes,
planned. 48, notice is there? 48. Huh? It is also there. It is there.
No, lordship, 48 notice is not available in the record, lordship. It has not come, but lordship, we have filed our objection. In objection, we have annexed 48.
Lordship, I have also annexed, lordship, for 48. It is page 49, lordship, my petition.
Otherwise, memo of arrest, the problem is that in this case, memo of arrest, I don't know whether I had perused it at that time. Memo of arrest reasonably provides the grounds. But 47 is, of course, it will not be sufficient. At that time, it was given. But while passing this order, I was not aware of that judgment. There's a judgment called Shwin Thakur Kakkar or something from Chandigarh. I mean, we had used it on. It was placed by council. So in that case, it was held that sometimes the memo of arrest, if the grounds are there, that can also fill in for 47 because memo of arrest is also given to the accused.
Specific to
To
the
the accused. But in this case, the problem is that the other accused have already been released on bail on the identical 47.
Lordship.
That is the problem. So probably we'll have to go by that only.
And page 49 is the para, notice 48, Lordship.
Para?
Lordship, page 49, Lordship. Intimation of arrest.
Page 49.
49, yes, my petition. It is 48 notice, that is not, the signature is not there. Lordship.
He has also mentioned memorandum of arrest. It has not been mentioned.
Since all the accused person are granted bail, Lordship, I also may be allowed to go on.
That is the difficulty I am facing. So probably it will be difficult to take a different view. It will be difficult to depart because others have been given. Because otherwise, that decision says that this can also fill in sometimes memorandum of arrest. If it is there, can also substitute. Substantial compliance it will be. Yes, I'm on this. I'm on page 84, which is there. You have annex, no? This one. 84 is your document.
Next one.
Claiming to be your husband. Arrested one person. Some more details are necessary. And you have annexed and page
49, Lordship. Page 49, intimation of arrest, Lordship, and page 48, the 47 notice.
same. I'll allow this, but I'll make an observation.
Lordship. On same ground, Lordship, my senior already submitted on in Sakidul Haq case, Lordship. On this ground, Lordship,
Yes.
submitted.
But I have to get that judgment again. Awesome. Yes. Okay, you can say sometime. Kami apa law, right? Nur Safi to Park law. BA 3160, bro. Effect. BA 3160 25. Order dated 23/10/2000. Thakur. MDECA. NCB. Second contractor details. In this to order 17/9/2025. BA 415. Para 2. Allegations are there. It is submitted by the learned counsel that he's seeking bail on the ground of non-compliance with the statutory notices under section 47/48 DNSS, and also on the ground of parity as 3 other co-accused, namely Shakidul Haq, Nur Safi, MD Nur Safi, and Sarif Chema Sesam have been granted bail on such grounds. filed orders dated 17/9/2025. Passed in BA 415/25 and order dated 23/10/25 passed in BA 3160/2025. Copies of the said orders have been placed before this court and peruse the said. The scan record as called for has been received. Heard, the heard reporting. The prosecution has also filed. The prosecution representing the investigating agency NCB has also filed an affidavit in opposition whereby the notice under 48 by way of intimation of arrest to the relative of the accused Basant Thakur, to the relative / wife has been annexed. A copy of the same has also been annexed by the petitioner along with the bail petition. The notice under 47, furnished to the present accused at the time of his arrest may be reproduced herein below. So, the memorandum of arrest given to the accused at the time of arrest is also reproduced herein below. The intimation of arrest given to the wife of the accused is also as under. Upon perusing these materials, these notices, I find that the notice under 47 is bereft of grounds of arrest. However, a notice by way of intimation of arrest to wife of the accused does have some ground, though whether the state ground, the intimation does have some ground, but it merely states that he has been arrested in connection with the seizure of the contraband. And it is not mentioned as to whether the seizure is from the accused or some other person. Therefore, it remains to be seen whether the said grounds would be sufficient. On the other hand, the memorandum of arrest does narrate some grounds. So, in a particular situation, perhaps if the grounds, sufficient grounds are enumerated in the memorandum of arrest, which is furnished to the accused person, that could constitute some substantial compliance with the requirement under section 47 BNSS. However, the same would depend upon the precise outcome regarding the same would depend upon facts and circumstances of the case. In this regard, a reference may be made to ... In the instant case, however, 3 of the co-accused have already been granted bail upon holding that that the notices under 47 which are similar or identical to the one in the instant case would not satisfy the requirement under section article 22(1) Constitution of India and the laws laid down the laws laid down by the Honorable Supreme Court in Bihan Kumar and Pravi Prakash. Therefore, in the given facts and circumstances, I am not inclined to depart from the aspect of parity with regard to the present accused vis-a-vis the other 3 co-accused granted bail on similar grounds. According same conditions. Ms. Prab made an observation. Made an observation. What was the bail bond 75,000. 1 lakh, 1 lakh. 1 lakh with 1/0 of the like amount. They are from state of Assam or outside?
Not lordship.
He's from outside.
Yes, lordship. The all lordship.
No, Vasant Thakur, he's from outside.
Basant Thakur from lordship,
Manipur.
Manipur lordship.
2 sureties of the like amount, identical conditions. As para 21 of this BA 415. 2223. Bail petition stands allowed and disposed of. And we have always discussed, like, this is an evolving law. So in that judgment, Dr. Vijay said, it has not been said very clearly whether memorandum of arrest can substitute for this. Suppose memorandum arrest has full details. But 47 is black. Today, it is very unlikely to take place, that kind of situation, because the same details will be incorporated in memo of arrest 47, 48 of the case in a way, with some changes. At that time, suppose they did not know 47 was bland, nothing. But memorandum of arrest, somehow they incorporated details. But whether it will substitute, it has not been said very clearly that yes, it will substitute. But it may sometimes. It may. So that's why it's not clear. I have also not said anything very clear. Just state that, depend on the facts. It may in certain circumstances. Okay. But this was more on parity. This was timing for something.
My lord, I have perused the scan copy, my lord. The 47, 48 notice, my lord, these are not in the scan copy record, my lord. And secondly, my lord, the date of my lord production, my lord, that is important, my lord.
Not in the record.
Not in the record, my lord. So my humble submission, my lord, that this 48, 40, 47 and 48 notice, my lord, that may be called for along with the, my lord, first order when they were produced, my lord. Because in the order sheet, my lord, it is recorded by the magistrate, my lord, whether the compliance has been done or not in respect of 47 and 48.
Yes, say.
Yes.
Compliance has been.
No, it is not in the
not
record,
there.
sir. There is only my order sheet of the session judge as well as the, my lord, the evidence of the witnesses, my lord. These are available in the record.
Page 22 is the prayer for sworn arrest, your lords.
Page 22 of your petition.
Lords.
Likely serious matter, otherwise
Even in the
trial
case of
has
sworn
already
arrest also,
progressed.
my lord.
Yes, your lord. The trial has been substantially progressed,
Likely
your lord.
serious matter, otherwise it's progressed. We could have taken a view. Which page?
Page 22, your lord.
You can call which court? Here?
My lord, this is pending, my lord, in session judge.
Session judge, your lordship. Gwalpara, your lord.
Gwalpara.
Additional session judge, Gwalpara, your lord.
Nice. Will it come in these days?
Next week, my lord, scan the only, my lord, these two notice, my lord. Along with their my lord, first production, my lord.
Yes,
What
page
is this?
22.
22 is the production, your lord. There is no mention in the forwarding report about compliance of this, your lord. Normally in the forwarding report itself, it is reflected that.
Yeah, it was in May 24. Time they were not so conscious. Okay then. Few days more. Take care. You should be able to. Did I dictate? No. Heard. No. The invoking section 483, the two petitioners herein, Than Talukdar and Bahar Ali, are seeking regular bail in connection with Sessions case number 6 of 25, pending before the learned additional session judge Gwalpara. The case arose out of Dudnoy PS case number 39 of 25 under section 120B302 IPC. Full stop. The learned council submits that the petitioners were arrested on 18/5/2024 itself, and in the meantime, pursuant to framing of charges, the trial has also progressed, and out of 17 witnesses, 13 witnesses have already been examined, and the remaining witnesses are more in the nature of official witnesses. Apart from this aspect, the it is submitted that the statutory notices under 47, 48 have not been complied with. At that time, I think it was for not for BN. This
BN, it is
50,
a CRPC or
58 notices or CRPC as these existed then within bracket have not been complied with. Towards this end, the learned additional people, after perusing the scan TCR receipt, submits that the said notices were not found in the scan record and submits that perhaps a requisition may be made to the learned trial court to send scan copies of the said notices if available. Considered the matter, issue a requisition to the learned trial court to expeditiously send copies of the notices under 47, so under 5050, yeah, 5058 CRPC, if available in the original case record, along with scan copy of the post production order before the learned magistrate. Post production order before the learned magistrate. The needful may be done. Yeah, expeditiously. That's right. The needful may be done expeditiously. List on
18-year-old also. Deeply obliged.
Deeply. 1812.
May I please, your lordship? May I please, your lordship? My lord, FIR, your lordship will find, my lord, page 14, my lord, operating part, my lord.
What happened? Incident?
My lord, what happened, my lord? The petitioner's mother-in-law, my lord, when they are that private nursing home, my lord, that FIR lodged by the, my lord, director of that nursing home, my lord. His, my lord, the petitioner's mother-in-law went there, my lord, asking for, my lord, treatment of, my lord, nephrology department because his mother-in-law is suffering from, my lord, chronic kidney disease, my lord. So they went there in the nursing home, my lord. They said, my lord, that we have nephrology doctor available, my lord. But when they
Private nursing home.
private nursing home, my lord, when they, my lord, went there, my lord, kindly see page 18, my lord. That date of incident is 1510, my lord. And here 1510 they went there, my lord. And the doctor, my lord, treated the patient, my lord. Dr. Ajay Kumar KRO, MBBS laparoscopic general surgeon, my lord. They had misled the patient, my lord. And subsequently, my lord, that patient died on, my lord. Death certificate I have annexed.
Dhubri Medical College.
No, my lord. Thereafter, my lord, she came to Guwahati also after that incident, my lord. Treated and again they went back, my lord. And my lord, and suddenly, my lord, she became serious, my lord. She was taken to Guwahati, but on way, my lord, she was become very serious, my lord. She was admitted to Borpeta Hospital, my lord. On way, my lord. And Borpeta Hospital, she was died on, my lord, 6, my lord. That
Borpeta Medical College.
Medical College and Hospital, 25, my lord, page, my lord. And the allegation of, my lord, that, my lord, demand of money, my lord, criminal trespass, that is not there, my lord. On the same incident, same day, my mother-in-law was admitted there in the informant's hospital, my lord.
Let us see the FIR.
1510, my lord, page 14, my lord. And after more than 1 month, the FIR has been lodged, my lord. Date of incident 15.
Gomoni PRC hospital is a government hospital?
No, my lord. It's a private nursing home, my lord.
Private nursing home.
Nursing home, my lord.
PRC.
In the top of the FIR, my lord, date of FIR 1810, my lord. 11, my lord.
1811.
Yes, and the date of incident 1510, my lord. After more than 1 month, lost the FIR, my lord.
That means after his mother died, mother-in-law died.
No, my lord. Mother-in-law died on 6/12, my lord. 6/12, my lord. What happened, my lord? In the meantime, my lord, the petitioner, my lord, filed a complaint to the, my lord, Honorable Chief Minister of Assam through, my lord, circle officer, my lord, regarding the anomalies and, my lord, wrong treatment in the said hospital, my lord. After that is filed on, my lord, 7/11.
And after that, 1811, the FIR has been lodged, my lord. After this complaint by the petitioner, my lord. Sir, I could hear now. There is a newspaper publication also there, my lord, in this regard, my lord. I have forward, my lord. I will file affidavit, additional affidavit, my lord, during hearing, my lord, annexing those two documents, my lord, during hearing, my lord, bail hearing, my lord. That same petitioner before your lordship, he lodged this complaint. The date is, my lord, 7/11, my lord. After that, they lodged the affair on 18/11, my lord. More than 1 month. After 1 month of the incident, my lord. Because of their treatment, my mother-in-law died, my lord. They said nephrology department doctor is available, but when they went there, they are treated by some other doctors, my lord. That is the allegation, my lord. And my mother-in-law died recently, my lord. Last Saturday, my lord. There is some works, my lord, regarding her, my lord, funeral and some other rights, my lord, religious rights. So I may be granted interim, my lord, so that I can participate in those, my lord. The death certificate, page 25, my lord, issued by the hospital, my lord. Page 25.
In the bring these documents on record. By
My lord, I will bring those documents, my lord, during hearing. my lord.
In the FIR, my lord, the petitioner, his wife and his son, my lord, they have been made accused in the FIR.
All family members given, my lord. Kindly see, my lord, 15 on
wife also. Wife and son also.
also, my lord, all the family members,
I
my
have
lord.
seen, my lord.
Say, my lord, because of that complaint, my lord, he lost this affair after 1 month, my lord.
And as per the, my lord, whatever my NFN is submitted, my lord, incident is of 15/10, my lord. And FIR registered, my lord, from the next page, my lord, it is on 21/11, yes, FIR has been registered, my lord.
After more than 1 month, my lord.
So case diary may be called for.
Can you repeat what happened? 1811.
No, 18/11 is the date, my lord.
FIR.
But the date of incident is of 15/10, my lord. You also will find in the, my lord, second paragraph, my lord, of the FIR.
1510. 1510 is
15/10, my lord.
more than a month.
More than a month. And my lord, if such incident happened, my lord, kindly see, my lord. Date of incident, they have said 15/10, my lord. There is some altercation that I admit, my lord, because of the doctor, my lord. But my lord, kindly see on page 16, my lord. On 17/10, I went there to test, my lord, the creatinine, and on page 17, the hemoglobin of my mother-in-law, my lord. If that incident happened, I would not have gone there, my lord, after 2 days, my lord, in the said hospital, my lord. Page 16 and 17, my lord. Kindly see, my lord. The date of collection of sample, my lord, 17/10. Date of incident, 15/10, my lord. So I prayed, my lord, my interim may be granted. And in the meantime, I will file those documents, my lord, as additional affidavit, my lord, during hearing, my lord.
Heard. Mullah. Sam Mullah. RJ Borwell and additional people. Invoking 482 BNSS, the petitioner, namely so and so, is seeking anticipatory bail in connection with Agomoni PS case number 157 of 25, the section so and so. With regard to an alleged incident on 15/10/2025, the superintendent of Agomoni PRC Hospital Nursing Home stated to be Agomoni stated to be lodged an FIR on 18/11/2025 with the allegation that the present accused petitioner in an intoxicated condition entered the hospital premises forcefully and created a hostile and violent environment threatening doctors and medical staff. He also attempted to commit extortion and defamation and public nuisance. This submitted by the learned petitioner counsel that earlier the mother-in-law of the petitioner had gone to that said hospital for renal treatment, but she was misled and given some wrong treatment. Thereafter, she had to be taken to another hospital, and on the way, upon becoming serious, she was admitted in Medical College at Barpeta, where she died. The wife and son of the present petitioner have also been named in the FIR. it is submitted by the petitioner that with regard to some
Especially
misdoings in the said medical establishment, he had written a complaint to the Chief Minister, Honorable Chief Minister of the state, a copy of which has been placed before this court, and it is submitted that he desires to bring the same on record through an additional effort. It is submitted that after the said letter is dated 9/11/2025. It is contended that though the incident dated back to 15/10/2025, after lodging of this complaint, this FIR came to be lodged on 18/11/2025. Third, learned additional people. What should I record as your submission? This speak for calling of the case diary.
And petitioner has been named in the FIR.
His name in I call for the case diary from the concerned police station. However, in the circumstances and giving my consideration to the matter, and allowing the prayer in this regard, it is directed that in the interim, 25,000 if one suits satisfaction. He will cooperate, appear, live, record, hamper or temporary, not hamper or temporary.
Appear before
Please.
10 days, within 10 days.
I don't give any time.
Okay.
Usually
Obliged, man.
appear within a reasonable time. This is the matter on
27/1.
27.
Obliged, man.
It's touched. Let us see. Wait, it's
Wait, please, Your Lordship.
20% interim.
Yes, Lordship. By this application, Lordship, we have challenged the order dated 19/6/2025. The Lordship will find the order is at page 30, Lordship. The petitioner was directed to pay 20%. They sought for 20%, but the learned trial court has given Lordship rupees 1 lakh, Lordship.
Which is what percentage is that? Approximately
10%.
Yes, this is a maximum 20%. Less can also be given. Let us see the impugn order first.
Is it page 30?
Just it's this judgment. Page 24. No, it's not page.
Annexure 7 now. Annexure 7, page 30, Lord.
Page 30.
30 and 31.
Can you read it?
Complaint is absent with steps by petition number so and so showing cause, steps allowed. Accused is absent with steps by petition showing a cause. Today is the date fixed for passing of an order on petition number so filed by the petitioner. Complainant under section 143A of the NI Act, saying before this court to direct the accused person to pay interim compensation to the complainant at 20% of the total check amount, which comes to rupees 2 lakhs. The petition is objected by the accused side by stating that it will be prejudice the accused person as he has never taken the said amount from the complainant and therefore prayed before this honorable court to dismiss the petition. Let me take into consideration section 143, newly added to the act, and legislative aim behind the provision is to
reduce the undue delay in disposal of the NI cases. The various factors that a court is to be considered while ordering interim compensation under this act, apart from the others, is that whether there is a case of complainant which could be proved in course of trial in due course. Here I take into consideration the various documents put forth by the complainant side and of the opinion that this case is a fit case for interim compensation under the said circumstances. The prayer of the complainant side is allowed. The accused is directed to pay interim compensation rupees 1 lakh within 60 days. As if here the petitioner also file a objection to the petition under section 143A of the NI Act. The said objection of the petitioner logic has not taken into consideration by the trial court while passes the order. In the said objection, the petitioner has stated that he filed a complaint case before the trial court, which stated the allegation that the said stake by which the petitioner filed the present complaint case was forcefully taken out by the respondent from the petitioner. And in this regard, he filed the complaint and cognizance was taken against him, Lordship. Your Lordship will find the complaint
was
case is
filed before the check bouncing proceeding or after?
it was filed on 23/2004 and complaint case was filed 27/3/2023, Lordship.
23, 2000?
To 23/2024. 20/03/2024.
And complaint?
And complaint case was filed on 27/7/2023.
27/7/2023.
23.
It was later, earlier, that means.
Yes, Lordship.
Check was filed, check bouncing proceeding was filed earlier.
After the check bouncing procedure was allowed.
Anyway,
so Lordship,
that's a matter of fact.
the
Anyway.
impugn order, Lordship, if you're after perusal of the impugn
order
Lordship
we have
filed,
seen.
there is no discussion about those complaints filed by the petitioner, and there is a judgment passed by Honorable Apex Court, Lordship. While passing the interim order in NI access, there are some parameters which has to be followed by the Thane trial court, Lordship. I'm thinking about the judgment of.
Yeah, you have given me this also. You have given me from the Supreme Court website. You have given, I think you have given me.
It's reported now.
Yes, now it's reported.
It's in 2024 4 SSC case.
Rakesh Ranjan Srivastava. It's a
Yes,
very
Lordship.
good judgment.
Paragraph
important
number 22 is deals with
Yeah,
27 is the
leading
relevant paragraph.
This is a leading case on this subject.
Yes, Lord.
Now,
Here in this
because the principles have been summarized.
yes, Lordship. Some discussion has to be there, Lordship. There is no discussion. State forward, Lordship has passed the order against me, Lordship. At least my case ought to have taken into consideration by the trial court, Lordship. Paragraph 27 is the relevant paragraph, Lordship.
Yes. See, in the main judgment, original judgment, the para is 19.
19,
But in
Lordship.
SCC,
Here is
the para is
27, Lord.
Actually, ideally, it
At,
should be
at that time, I
same.
could not find
Should be
out.
same. No. Ideally, it should be the same as the original judgment. Anyway, that's another matter. Doesn't matter. So, this is the leading case.
Yes,
So, I have gone through prima facie case has to be seen and prima facie defense.
Defense,
has to be
Lordship.
seen.
If the defense of the Lordship accused is plausible, Lordship, in nature, the learned trial court has a discretion to refuse to grant the Lordship interim. And in this judgment, Lordship, there is another observation by the Honorable Supreme Court. The presumption under section 139 will also not come into play while considering the application under section 143A, Lordship. Because there was a Lordship business transaction between the petitioner and the respondent, Lordship, and the agreement was executed, and as per agreement the petitioner was supposed to provide 120 numbers of labors to the brick factory of the Lordship respondent. He provided 80 and out of
Now you have to show the court, as you know, is that there is no prima facie case, right, for him. And there's a prima facie defense. You have a prima facie defense. So let us see the matters. The record has come.
Record has not called for Lordship. In last occasion, you mentioned something. Yes.
Won't you need the records? I think
Yes,
we need the
for
records.
that, Lordship, if your Lordship perusal record is required, Lord.
What do you say, sir?
This, Lordship, this, as we go through the case of the, appeal filed by the appellants, we find that the due process of filing this NI case was done in the Hosei court. Okay. This on 12/3/24, the petitioner was served with legal notice. He did not tell anything about the check being obtained through coercion. Then, when the demand notice was served, and he received on 10/7/23. Till that day, he was not sure what to do. What about this? Now, what happened? When the case was filed, he had been avoiding contact. He had not been coming to the court, and ultimately a valuable warrant was issued to fetch him in the court. He came to the court on 12/3/24 and he obtained bail on 12/3/24. And he filed this case. Nogam complaint case was filed on 23/14 after the 8 days of his getting bail in the Hosei courts. Because his house is in Nogar district, he filed this case. My point is this: when he is this, he feels that he was coerced to issue this statement. Why didn't they go to the police to lodge FIR? Number one, he did not do it. Now, another point is that
Or
he
even
write.
Complaint case was filed later. Anyway, but just pause for a moment, sir. But because so this is kept as part third, but I don't know why we have not got the record till now. We should have, because the record should be called on the first day only, because we'll be handicapped without the records. Otherwise, complaint, yes, annex, but other things, set of documents and everything to see the prima facie case. Otherwise, let me have a look at the complaint once. Give me 2 minutes. Let me go to the complaint once. This is Abdul Kalam, huh? Abdul Kalam.
Abdul Kalam.
This agreement is very necessary for perusal. This agreement, which was made regarding this payment. And the question is that, of course, that is a matter of defense. Nothing can be prejudged. But what about the signature? Does he deny the signature? Because the presumption will come. If the signature is admitted, the presumption will come.
The objection he has denied, Lordship, that
there is no, he never taken any money from the,
Is the objection which you filed there
yes, Lord.
before the court.
Yes, Lord.
He could not supply the labor if this is true, this business understanding. He could not supply the labor. It's okay, you return the money. Suppose if that is true. So therefore, need to see that agreement. Need to see that agreement and what he had stated in the objection.
Lordship, may I?
Yes, you can complete.
In the complaint which the appellant has filed in the Nova Sessions Court, Sessions Court, he writes on page number 18, the accused summoned me to the Hojai police station on 21/4/23, and the police asked us to settle the matter and sent us home. We both returned home. The accused entered my house at 11 p.m. on the same day. His house, which is about a distance of approximately 50 kilometers from Hojai, same day on 21/4/23, and abused me in various obscene languages and forced me to sign 3 blank checks and 2 blank stamp paper worth ₹50, which are still with the accused. This is they are claiming. I will have a lot of problems if this remain accused. Here in this appeal, my learned friend writes,
That is my question without prejudging, because that's a matter of that is, and this is neither a caution proceeding. That does he deny the issuance of the check? That the check was
he's saying that he signed the check, but it was through coercion.
through coercion.
He is stating that
He
it
signed
was
the
through
check.
coercion.
But if the signature is admitted, the presumption will come.
Signature is admitted because he says that they will say. Now here in their
Admission in the trial.
in their case, they are saying that the accused entered my house at 11 p.m. on the same day. That is, the accused summoned me to the police station and the police asked us to settle the matter. This is there. And here in this case, in the plaint, they are writing the complainant along with the hooligans took the petitioner to his home forcefully took from his home forcibly with the help of police and obtained his signature upon 3 numbers of checks and 2 numbers of blank stamp papers. The point is that can somebody enter and get directly into the checkbook, and that too in his village at 11 o'clock, which is densely populated. Even the police people do not like to go by fear. And he is known as Laden. He is so ferocious person. Everybody knows him, right?
Anyway. But interim order is also there. We have to get it quickly. Otherwise, this is affecting the further arguments on behalf of the petitioner side and also the learned counsel for the respondent. Respondent/complainant. Proper adjudication, proper and effective adjudication of this matter necessitates perusal of some portions of some materials which would be available in the case record before the learned court below. Therefore, issue requisition for scanned copy of the case record comprising the relevant documents. Needful may be done by the registry. Interim order has to continue. What to do? The interim order first earlier, fight order dated 18/8/2025. So I'll continue till the next date of listing. After the vacation, immediately after the vacation. Let us fix it on 8/1. 8/1/2025. Will it come by then? Come.
Highly of it.
Is the matter in the admission column?
24.
I plead your lord. So this criminal petition is for quashing of as well as quashing of the affair as well as the PRC case arising from thereafter. My lord, do you please to find out the FIR at page 13.
Record say कौन? Page 13.
Yes, the allegation is basically carrying of gold bar without any document. That is the basic allegation. My
Page,
lord,
yeah, page 13.
13.
Just a minute. Yes, you want to read it?
Yes, my lord. With reference to the subject cited above, I have the honor to inform you so and so. I am reading from the second paragraph, my lord. During checking at about 8:30 a.m., we noticed a person in a suspicious manner who was traveling in coach number so and so of the said train. On asking, he disclosed his name and address as Amarnath Ashok Saman, so and so years, son of so and so, and revealed that he is carrying 13 pieces of gold metal biscuit by tying around his waist without any documents. He also reveals that he carries gold regularly from Tripura to Maharashtra for smuggling purpose with the help of other members of the racket. Thereafter, he was deboarded from the train at platform number so and seized the said suspected to be gold metal under videography along with a cash of rupees 64,500 and other articles. On being asked him to produce any documents about the recovered suspected gold, he failed to produce any documents nor satisfactory reply about the recovered gold. After that, the apprehended person and recovered seized items are brought for further necessary action. That, sir, the accused person is involved in smuggling of gold. The seized suspected to be gold of total weight of rupees 1.5 to 3 kgs is strongly suspected to be smuggled and illegally transported without paying any taxes, etc. Sorry, my lord. Thereafter, the FIR was registered under section 120B, 379, 411, and 413.
120B,
379, 411, and 413.
413.
Yes. So, number one, 379, my lord. So, regarding theft. So, where is the allegation? Where is the material in the evidence that regarding any theft, my lord? So, whether that property has been stolen from other any complainant or any informant? No. Number two, 411 and 413 receiving of stolen property. My lord, either he can be a thief or he can be a receiver of a stolen property. He cannot be both. And my lord, no offense can be made out from this FIR because apparently prima facie no offense can be constituted from this FIR, my lord. And that's why
Do you need
this case has squarely covered, yes.
Do you need documents to carry gold? Do you need? I don't know. Suppose I am carrying gold biscuits.
Even if my lord,
ornaments.
Even if my lord, if he is carrying gold without any documents, that can be penalty, not a penal provision.
Customs.
Not custom under the tax, GST and even if.
I don't know. To see.
But if your lordship uses the Customs Act, then that is a different issue. That gold should be a foreign gold, my lord.
Customs Act regulates trade, import.
Yes,
import, export.
from import and export.
It has to be anything imported has to
has
to pay the customs duty.
Yes, yes, definitely. So
Otherwise,
there
it
is
will be a
there is no allegation that that gold is a foreign origin.
Acha, anyway, so after the FIR, investigation resulted in a charge sheet.
Yes, charge sheet has been filed. Lordship will please to find the charge sheet. The relevant portion is at page 28. It's a translated copy.
Let us read this one. Charge sheet. Original charge sheet is that? This
Yes, yes.
I'll just flip through. Flip.
The vernacular is at 29. Charge sheet starts from page 18.
Starts from?
Charge sheet starts from page 18.
I'm on page 28.
Yes, yes. My lord, page 28 is the brief history. Yes. So 28, I'm reading, my lord. If you
No, I've gone through already.
okay.
I've gone. It starts from 18. It starts from 18. Then?
My lord, charge sheet has been filed. Then now
What is this mention?
stay
The
with-
gold belonging to Sonamuni Basuni Kedasar.
my lord.
No, this narration, second para of page 28.
Yes, as per the
Who's this person?
investigation, the complainant stated.
The
The complainant stated that gold belonging to Sonamoni Basuni Kedasar.
Who's this person? Sonamuni?
The complainant stated that as a result of the investigation, gold belonging to Sonamoni Basuni Kedasar was recovered and sent to State Testing Center for examination.
I did not understand. Anyway,
No,
One else.
my lord, I may be allowed to read the vernacular then. There might be some প্ৰকাশ থাকে যে তদন্তকালত পূৰ্বৰ তদন্তকাৰী বিষয়া তদন্তকালত পদকীয়া গ্ৰেপ্তাৰ কৰিছে আৰু মোকৰ্দমাৰ গ্ৰেপ্তাৰী পদকীয়াৰ দ্বাৰা উদ্ধাৰ হোৱা সোণখিনিৰ
you read from
No, no.
third paragraph.
29 page, second.
29 second
প্রকাশ
paragraph, my
থাকে
lord.
যে পদকীয়া আজি পৰ্যন্ত উক্ত
29, Lordship, page
Yes, yes.
29 second paragraph, my lord. তদন্তকালত পূৰ্বৰ তদন্তকাৰী বিষয়া তদন্তকালত পদকীয়া গ্ৰেপ্তাৰ কৰিছে আৰু মোকৰ্দমা সংক্ৰান্তে গ্ৰেপ্তাৰী পদকীয়াৰ পৰা উদ্ধাৰ হোৱা
read the third paragraph. প্ৰকাশ থাকে যে
প্ৰকাশ থাকে যে পদকীয়াই আজি পৰ্যন্ত উক্ত জব্দকোট সোণখিনিৰ কোনো বৈধ নথিপত্ৰ
আচ্ছা, that's okay.
আদি জমা পৰ্যন্ত
This name comes where?
I don't know that there might be some mistake, my lord. I'm sorry, my lord.
Copy
In translation.
No, copy paste.
Yes, Lord.
Yes, yes.
That is something on
Afflicts us all.
in vernacular. No
Yes, my lord.
name is mentioned. In vernacular, no such name is mentioned.
No mention.
Some mistake. Anyway, we ignore it. So,
So prima facie from all materials, my lord, from charge sheet, from FIR. So no case can be constituted, no offense can be constituted under the BNS, my lord, or any earlier IPC, my lord. Because I've been fully squarely covered by Lordship is aware of Niharika infrastructure. So parameters laid down in RP Kapoor and Fazan Lal, the celebrated case, my lord, Fazan Lal, that parameter has to be applied, my lord, regarding that. And RP Kapoor judgment, it was prior to CRPC amendment, my lord.
should we look at the case record?
Lordship, actually, my learned friend K. Boyso
He's
has
looking
gone
into
through the records.
He's looking into
So he's in legs in some other court.
Yeah.
I could not go through lot.
No, there's no ingredient of theft. There's no ingredient of stolen property. Well, conspiracy, one person cannot be.
Yeah.
Habitually dealing with that they've given that he's regularly smuggling gold. That's why it's been given.
Yes.
Smuggling and theft is different things.
Yeah.
Smuggling and theft is a different thing.
But without any valid documents now.
That's why why I asked this question. That if I carry gold, not as ornaments, as gold say, do I need papers?
It's actually it is.
My lord, as far as my knowledge,
Frankly, I don't know.
It is
as far as my
Because
knowledge,
I've never carried.
so smuggling and
there
all,
is
I
no
don't know
limit
then,
how
I
much
don't
of
have
gold a man can carry. There is no limit as far my knowledge is.
But I think any person carrying, 10 gold biscuits
No,
in
there
an
is no
airport
law.
will be in trouble.
Yes, that he'll be in
Definitely, he'll be asked questions.
Definitely, he will be asked
But
question
the legal
for the tax purpose, my lord.
legal
Yes.
portion that do you need papers?
Yes.
Like we know that we need papers for an arm,
Yes.
pistol.
Yeah.
So that is why I wanted to know 413 and this only we have to see 413 and 411.
Yes.
But
So
there has to be
no.
some 411. But see, when a property is recovered, it can be suspected to be stolen property.
Exactly.
But after completion of investigation, there has to be some definite material
Right.
that it is
Stolen from
so
somebody.
Then only you can charge sheet someone
Yeah.
under 411. But that's why let us see, because that's why I did not find anything in the charge sheet.
Known to be habitually dealing in such stolen
Yeah.
property, then also
Then
section
we have to
413
see
will come into.
stolen from where, suppose.
Otherwise, prima facie case is
Perhaps
missed out.
police should have consulted customs department in this matter. Maybe. What are the criminal offenses under Customs Act? We don't.
No.
I mean, what are the criminal offenses? Like all taxes have penal provisions also.
There
Like
are
income
penal
tax
provisions.
has-
There are penal provisions under custom, but
Penal provisions are there. One of our magistrate here, he tried
Yes,
income
yes,
tax cases.
yes,
And
yes.
GST also we know
Yes.
there's a criminal element. Customs also has, right?
But customs will act into play when the property is of foreign origin. There should be important export transactions, my lord.
That
But,
is a
but there is no
foundational fact.
allegation that property is of foreign property.
That is a foundational fact, no?
Yes.
For customs to have jurisdiction.
Yes.
Anyway, can I have a look at the Customs Act? I just want to see whether there is anything pertaining to gold.
Lordship.
I will not bother you, madam, because Boysoy is already looking into them.
Lordship.
He will be.
Thirteen pieces of gold biscuits, Lordship. That too, while he was about to board on a train. The entire scenario
No,
seems to be a.
Definitely, in these
unsuspicious.
transport junctions like railway station, airport, this biscuit carrying gold biscuits will land the person in trouble.
13 pieces, not a small. amount.
But suppose so that's why I said two questions.
Then
Whether papers are necessary,
Yes,
under what law,
yes,
and if papers are not available, suppose papers are necessary. Three questions.
yes,
Whether papers are necessary to carry such gold in such form.
yes.
If necessary, under what provision?
Yes.
Thirdly, if the papers are necessary and I am unable to show these papers, then what are the penal consequences?
Yes.
These are things.
So that Lordship.
It's
may
not in IPC.
Pass in direction to that regard, Lordship.
Yeah.
It is,
In that direction.
yes,
To?
direction to the ION. That is
For what,
required
sir?
for whether they have
Already
made
charge sheet has been
investigation
filed, my
under
lord.
under
What remains?
those Lordship parameters, Lordship.
Already charge sheet has been filed. What remains, my lord?
Let him come, because there's a
They
lot of
have,
narration in
number
the
one, they
charge.
have failed
in
to
the-
produce any valid documents and satisfactory reply could not be given. At a
There are a lot
My
of,
lord,
Why they
they are
were carrying
13.
13 pieces of gold biscuits?
Exactly. They have business, gold business, my lord. My lord will,
So to that
my
regard,
lord will
some
see,
authentication-
if I come to the facts,
This
then my lord will
document,
come
he
to,
has to show the
come to
documents. That I have a
Page
business
31, my lord.
transaction on board.
Yes.
Some authentication has to be there, some document has to be.
my
there
lord
to
may
that.
come to page 31, my lord. That is the original receipt. It's a GST receipt, my lord. of that
Yes,
13 pieces of.
the charge, the scan copy of the case diary has many narrations, statements are also there. But
Lordship.
I have some problem with the handwriting, so I think I'll need Boyso's help.
Lordship.
So we'll wait for him, but I'll just see this, then we'll keep it on. Will he come today or another day? Will he
He
come?
wanted to see Lordship.
Which page should I see? Page?
31, my lord. So he is the buyer. Our gold. They have jewelry business basically.
Whether he is a goldsmith, Lordship, whether he has.
I've seen this, Mangolam Chain Private Limited.
So I don't need to
Chandra
prove
Vilas
whether
and
I'm a
Chandra
goldsmith or not in this case, my lord. I'll prove before the trial court.
No proper seal, no proper endorsement, Lordship.
Our gold jewelers,
No proper endorsement, Lordship.
Amarnath Sawan. It's a GST bill, my lord.
Amarnath Sawan. There. It should be here, also available here. I think.
So it is not there, my lord, because we wanted to submit these documents, but police denied it. That's why it is not on record. It's not that we do not have any document. We have that document, but that time we couldn't produce.
Total amount is 92,85,000.
Yes, definitely 13 pieces of gold.
It's not a such a big amount.
As such, it's a
Transaction
big
of-
amount. That's
Transaction
why.
of Lordship, that's a big amount.
But there is
Without
a
any valid
difficulty, yes,
documents.
but that's true, but I'll have a look at
Either
the
he has
customs
to
act.
be a
But these
businessman.
sections are, they're, the linkage is weak. 411, all these IPC sections.
Yes, yes,
the linkage
otherwise,
is weak.
otherwise.
Anyway, let us wait for the part.
My lord.
If possible, take it today only, otherwise it's pretty.
After some time, my lord.
Just sometime. And if you can spare some time, madam, that the customs act, if you can just see the penal provision.
Lordship.
And if there's anything regarding gold
Yeah.
in the meantime. This is an interesting case actually.
And Lordship, there's a prayer of Jimma of that gold that has been, prayer of Jimma petition has been rejected. It's on 28/12.
Gold is in the treasury.
Yes, my lord. That is in custody. That is another issue. So I have been informed, my lord. It is in the police custody itself, not in treasury also.
No, they've given a document.
My lord.
They have
Okay.
treasury. Okay. Let us touch the other matter.
26.
May it please your lordship.
Yes.
Your lordship, the backdrop of the case is that, lordship, petitioner was arrested in a case where he was not named, lordship. And at the time of his arrest, he was on his own vehicle that has been seized during his arrest. And subsequently, lordship, on the intervention of this honorable court, he was released from the custody. Thereafter, lordship, he prayed for Jimma of the vehicle, lordship.
Vehicle.
Yes, Jimma of the Bolero vehicle owned by him. So meanwhile, lordship, before the police case, he newly purchased that, and before that, 2-3 months EMI was there, and he has paid his 2-3 months EMI. Thereafter, because of the police case, lordship, because of this judicial custody, his income has been blocked. He being the sole earner, so his income has been blocked, and he could not pay the EMI, and there happens 2 lapses of 2 EMI, lordship. And at the moment when he filed Jimma petition, the bank has also filed a Jimma petition before the judicial magistrate, London judicial magistrate, and the
Learned Judicial Magistrate granted the interim jimma of the vehicle in favor of the bank lordship. Yes, being aggrieved lordship, this petition has been preferred, challenging the interim jimma of the passed by the Learned Trial Court. That is at page 16, Annexure 2, lordship.
Page 16.
Page 16, that is the impugned order, whereby the jimma of the petitioner has been rejected and the interim jimma of the sought by bank was allowed, lordship. Against this application has been preferred, lordship. Now, lordship, basically sole contention of the petitioner in this petition is that the Learned Trial Court has acted out of jurisdiction because in a criminal case where she had no power to hand over custody of the vehicle in favor of the bank lordship. That is one aspect. And the other aspect, lordship, the bank could have availed the alternative remedy, could have availed alternative for recovery of the loan instead of filing jimma application and getting jimma in their favor, interim jimma in their favor, lordship.
Let me read.
These are the
Yeah, I'll just go through the impugned order once myself. Or do you want to read it?
yes, I can read, lordship.
No, let me go through it myself.
May I, lordship?
You can read if you want.
That is at page 16, lordship.
Yes, we are on page 16. Yeah.
Now the Learned Trial Court, while while considering this as application, lordship, the application of the while rejecting the application of the jimma petition of the petitioner, lordship, did not consider that that petitioner is a registered owner of the vehicle.
He has referred to some, should we? I'll read it myself or?
Yes, lordship.
I can. He has given reasons cited to case law also. Anyway, anyone from the RTO for the
lordship.
bank?
Yeah, lordship.
I'll come to this.
Yeah.
Okay, I've gone through. It's referred to one High Court decision also. We can see it later anyway. Now we should be on the facts at the moment.
Yes.
So this is what he has said, that the police said investigation is not necessary for investigation. So the JIMA was, interim JIMA probably was required to be given, but there were two JIMA petitions.
They were
Whether
to
to the bank and petition.
without considering the JIMA of the registered owner.
Learned court below said that, after referring to some case laws, said that a contract of hire purchase creates bailment,
Yes.
concept of bailment, which is there in the contract. And that the actual owner continues to be the registered owner is this person, but he has referred. Therefore, interim custody was given to the bank. That is his reasoning. Anyway,
Whether that decision was rightly taken. I mean,
Yes.
she has traveled out of jurisdiction, Lordship, because that was a criminal proceeding, and to look into the other aspect, deciding in a criminal petition is definitely suffers from want of jurisdiction. And
now who's entitled to interim custody in case of a hire purchase vehicle if there is default in payment? Suppose that
Lordship,
is the question before us.
Lordship, may I take your Lordship to
now we can-
the fact under what circumstance petitioner became the defaulter? And petitioner, just before the incident, Lordship, just before 2 months ago, he purchased the vehicle, and thereafter, because of the implication, and not that petitioner is a affair named. He was implicated by someone of co-accused. Thereafter, he was taken into custody. And at that time, Lordship, this vehicle has been seized along with during his arrest, Lordship. That was the legal. Thereafter, when he and at the time of his arrest, Lordship, even he paid 2 numbers of EMI, Lordship, when he was inside also. So the conduct is such that they have stated that his conduct was not good. Even when he was in custody, he paid 2 numbers of that. Thereafter, so there may be a lapse of 2-3 because of the fact that his income has been blocked, and he was there for a month, and no other person was there in his house to look after all. So suddenly there was a lapse, Lordship. Now, Lordship,
The vehicle was detained in connection with another case.
another case,
Another
Lordship.
case.
Another case. The case
The bank,
where may I take your Lordship to
bank
that?
stepped into that situation, and
Yeah.
due to the alleged default,
Yes,
they
everything was fairly stated, and everything was fairly stated before the court below, stating the facts, giving the evidence. This is the receipt, and we have paid this. We undertake to pay further in future. But in spite of that,
anyway.
so that was the situation, Lordship, where interim order has been passed. Now, Lordship,
So that
this
is, if I've understood correctly, madam,
Lordship.
is that in terms of the agreement, the bank was within its rights to take back the vehicle as like all other hire purchase agreement, but the magistrate was not justified in giving the JIMA to the bank.
Yes.
The bank would have invoked that
Bank-
agreement
yes,
to
that-
take back the vehicle.
Yes.
But
Lord-
the magistrate could not have given in a criminal proceeding JIMA to the bank, right? That
Bank.
is your main concern.
That is one of my.
We have to see
and
whether that is legally correct or not.
Lordship, and other aspect, we have filed an additional affidavit also responding by filing a response to their opposition, Lordship, wherein we have also annexed one circular of the Reserve Bank of India. How they can, that is also there. We have annexed with the additional affidavit. At page number, Lordship would be pleased to find that at page number 11. Even at this Lordship, additional affidavit, para number 8, I have made a categorical statement about the circular of Reserve Bank of India.
Page 11.
Page, yes, Lordship. Para number 8, Lordship.
Running page, how much?
Running page should be,
This is the affidavit in reply.
affidavit in reply to
Then you
the
have this,
petitioner, Lordship.
this is the, I think, This is the RBI circular.
Oh.
All scheduled commercial banks.
That
To all scheduled
one is by them, one is by us. Reply has been filed by us.
All scheduled commercial excluding RRBs. Annual policy.
One reply is there, Lordship.
Taking possession of mortgaged property, hypothecation.
They should look for, Lordship, alternate remedy that is available for recovery of this loan and all. That is
That is
open
your
to them.
opinion. That is your
Yes.
Understood.
Lordship, additional affidavit reply, para number 8. Lordship is
Yes.
handy with that.
I'm on your reply.
Yes.
I'm on
So
para
para number
8.
8.
Para 8.
Take your, yes, Lordship.
Para 8.
That the petitioner further begs to state that the Reserve Bank of India explicitly states that the recovery of loans or seizure of vehicle could be done only through legal means in terms of the direction of the Honorable Supreme Court. For the sake of brevity, the relevant portion is provided herein below. Taking possession of property mortgage hypothecated to banks. In a recent case which came up before the Honorable Supreme Court, the Honorable Supreme Court observed that we are governed by the rule of law in the country, and recovery of loans, seizure vehicles could be done only through legal means. In this connection, it may be mentioned that the scrutinization and reconstruction of financial assets and enforcement of Security Interest Act 2002 and the Security Interest Enforcement 2002 frame thereunder have laid down well-defined procedure not only for enforcing security interest but also for auctioning and the movable and immovable property after enforcing security interest. It is therefore reasonable that the bank rely on legal remedies available under the relevant statute while enforcing security interest without intervention of court. Where banks are incorporated in reposition clause in the contract with the borrower and rely on such a reposition clause for enforcing their right, they should ensure that the reposition clause is legally valid, complies with the provisions of Indian Contract Act in letter and spirit, and ensure that such reposition clause is clearly brought to the notice of the borrower at the time of execution of the contract. The terms and conditions of the contract should be strictly in terms of the recovery policy and should contain provisions regarding number one, notice period before taking possession, the circumstance under which the notice period can be waived, the procedure for taking possession of the security, and a provision regarding final charge to be given to the borrower for repayment of loan before the sale auction of the property given for reposition of the borrower and the procedure for sale auction of the property. So that circular I have annexed. So my case falls under that circumstance. It was a special. It was beyond my control. I was in judicial custody for a month. My entire lordship, this income strategy has been blocked. And I being the sole earner of the family lordship, because of the detention, that challenges me to face such situation of default lordship. So nothing was intentional, it was the circumstance. And these circumstances were well placed before the court below lordship, stating, giving the EMI, even that time 2 EMIs were paid when the impugned order has been passed. So in spite of that lordship, the interim chima, and even ignoring the undertaking that I'm in future, I'm willing to pay. I undertake to pay the remaining part of the interim custody has been handed over. So that has caused me highly prejudiced lordship.
Anyway, so we contract. Take some time. See. Right. Contract.
Here we are the financial, the law is settled, independent Supreme Court has said that the higher purchaser, your lordship must be aware of that.
Educate me on that.
But before giving Zimma, my lord,
Contract, Indian contract. Contract paper. Oh, right, you carry on.
my lord. But even before giving the Zimma, my lord, because both Zimma petitions filed simultaneously,
Yeah.
my lord, report was called from the police. And the police in its reports have stated that their vehicle was not needed. So it was not a subject matter of the investigation. But so the vehicle was not needed by the police for any further investigation. And the court has rightly directed that the vehicle should be in possession of the bank, my lord. But here, my lord, the petitioner have entered into an agreement with the financier, my lord, where in the default, where in the event of default, what steps can be taken of. If your lordship may come to page 49 of my affidavit in opposition, there is one relevant clause with like this.
Page 49.
49. This is the agreement. I'm only referring to the relevant portion. Forty-nine of my affidavit in opposition.
Yes.
Yes, my lord. Top of it, my lord. Remedies of bank and enforcement. If I may. Clause. If any event of default or any event which after the notice or lapse of time or both would constitute an event of default shall have occurred, the borrower, the petition, the borrower shall forthwith give banks notice thereof in writing specifying such event of default or such event. On the question whether any of the event of default has happened occurred, the decision of the bank shall be final, conclusive, and binding on the borrower. Bank's right of determination of occurrence of events of default shall not be limited or prejudiced by the absence of any notice from the borrowers under the preceding subclause. But here, 30.3, these are the, I will not go through it, these are the conditions. The bank can even acquire without going through court or any notice the vehicle if they are on default. And if your lordship may come to the statement of account, which your lordship will find at page 82. 82 months. And after giving the finance, my lord, he has paid only 2 times, my lord. Well, ultimately, these are the public money, my lord.
No, that is another.
My lord.
Will not go
My lord.
that aspect.
Yes,
I'm
yes,
only on
he
that.
has defaulted. My lord. He's
That-
still now
that-
there's a
I'm only
default.
on that who is actually the owner. That is also a civil aspect. But more than that, whether in a JIMA proceedings it should be given to the bank or the bank should be left to invoke its civil remedies in terms of the agreement, right?
Well,
So
yes.
legal position we have to see.
Yes, in as per the contract, Malak, as per the contract which was entered, Malak, there we had the liberty to seize the vehicle even without notice, Malak. However, this is the case where we have informed
Without intervention of court. That
with
is
the intervention of the court. We had the right. But however, we have gone through the intervention of the court because the vehicle was seized by the police and it was known to us. Then we started. And Malak, apart from this,
the
case,
bank wanted to take advantage of that situation.
well, because we have been
Not
serving,
illegally. I mean,
No,
they
yes,
wanted to take advantage.
my lord.
And I'm not saying in a unfair, in a.
Yes, Malak, I understand. And there are some instances where
That seized, so they were already agreed by non-payment, alleged
Non-payment.
non-payment. So taking advantage of the situation, they also put a JIMA application.
Yes,
right.
And also, man, notice was also served before even the ZIM application, man, at page 79. There's another case which has been pending, man, under section 25C of the Payment of Settlement Act. But here, man, we do not have any objection of subject to the contingency pays all the remaining due. Then she may take over the vehicle, man. That is one condition. Now, man, coming to the legal aspect, who is the owner, man, if I may place one judgment, man, of the Supreme Court.
This is now we have come down to the decision has to be more on law.
Yes, man.
No, the facts we have negotiated.
Yes, man. Your lordship has understood the facts, man. This is.
I think I have reasonably understood.
Yes, actually, lordship was correct, man. That because we have been sending notice, we have been agreed, having come to know. We have also applied through a legal
Banks
means.
have their own pressure to recover.
Yes, and the police report was very crucial.
We have to take the correct legal route. That is Madam is content.
Yes, ma'am.
That correct legal route, whether it has been taken by the magistrate.
Madam, if I may, 2020 10 SEC 339.
I'll have.
Your lordship has it, madam? And para 74.
Magna.
Yes. Magna Financial Corporation.
I'm not confident.
If I may, if your lordship may come to paragraph 74.
Just.
2010. If I may, my lord, para 74.
74?
Yes. A hire purchase is, however, a more complex transaction where the owner enters into a transaction of hiring out goods on the terms and conditions set out in the agreement. And the option to purchase excessively by the customer on payment of all the installment of hire arises when the installments are paid and not before. In such a hire purchase agreement, there is no agreement to buy goods. The hire, being under no obligation to buy, has an option either to return the goods or to become its owner by payment in full of the stipulated hire and the price of exercising the option. This class of hire purchase agreements must be distinguished from transactions in which the customer is the owner of the goods, and with a view to finance his purchase, he enters into an agreement which in the form of a hire purchase agreement with the financier. But in substance evidences a loan transaction subsequent to a hiring agreement under which a lender is given the license to seize the goods. In the next paragraph, my lord, in the aforesaid case, the majority of the judges were of the view that the intention of the appellants in obtaining the hire purchase and allied agreements was to secure the return of the loans advanced to their customers, and no real sale of the vehicle was intended by the customer to the appellant. The transactions were merely financial transactions. The judgments of this court in so and so was rendered in the context of the liability of a hirer to pay sale tax on the goods acquired under the hire purchase agreement. Here, the relevant section has been quoted. The paragraph 76, clause 6. The object of the hire purchase system was to help to finance the customer in order he might purchase the property. Though that was the object, the transaction took form of a hire purchase agreement. The main feature of the agreement, apart from the small variation, was that the dealer was a financier, continued to be the owner till the terms of the agreement were fully complied with the customer, and the option to purchase the same was exercised by him. I'll come to the straight away the relevant 77. The law which emerges from the judgments of the court referred to above is that goods are let out of hire purchase under a hire purchase agreement with an option to purchase in according to the terms and conditions of the hire purchase agreement. The hire simply pays for the goods and for the option to purchase. 78. I'll come to 79. The financier continues to remain the owner of the vehicle covered by a hire purchase agreement if all the hire installments are paid and the hire exercises the option to purchase. Thus, the financier takes repossession of a vehicle under hire upon default by hire in payment of hire installment. The financier takes repossession of the financier's own vehicle. That is the observation. After discussing everything, it remains that the financier, until all the loans have been repaid, the financier remains to be the owner of the vehicle. Here some submitting of
That's okay. And just I have a query to myself. Just enlighten me. And then in that case, okay, this is of course the law laid down. Then in the registered record of the transport, suppose you take a loan or me take a loan, from this thing. Then in the registered or transport office, whose name would be there?
The name of the who purchases will be there, but in the, if I may, in all the registration certificates, it's also been, if it is hypothecated, it's been written, it's hypothecated to the so and so bank, whichever bank it has been purchased. And the law requires that until all the dues are being cleared, the financial.
That we also see in vehicles.
Yes, they hypothecated. Yes, if I purchase a vehicle, it will be in my name. But if I take loan from any particular bank, it will reflect the hypothecated to so and so bank. That is the.
But according to this law laid down by Honorable Supreme Court, the real owner though would be the financial.
Yes, it is the financial.
Though in the records, technically you are the owner.
I am the owner. Even I'm off the record, I'm something. That bank doesn't have any objection to giving the vehicle.
No, I'm just trying to.
And now say whatever dues are left, I do not know, if he can pay, he can take away the vehicle, and if he undertakes to pay, continues to.
The bank has a different interest. Bank is the business of bank. Lending. People, bank wants to lend more and more. Because that is the profit. That's the business. And bank wants to lend more and more and want all the loans to be repaid with interest.
Both sections they are under pressure in giving loan and also taking possession. That is my humble submission. That what the law laid down by the Honorable Supreme Court is clear that the financier is the real owner until all the dues have been cleared. So, my lord, and the learned magistrate, my lord, has given the Jima after going through the reports of the police, my lord, whether it was needed for the purpose of investigation. That aspect, your
The
lordship.
learned magistrate referred to one judgment of Supreme Court. Is this?
Has
He
read
referred
one
to
high
this
court judgment, my lord.
No, he referred to an older judgment, 1961.
Yes,
He
this
referred
is
to a criminal matter it appears to be a Jima matter of
yes,
our High
Yes.
Court.
my
Whole matter.
whole matter.
Whole ma-
I'm submitting some new
have
ones,
that?
my lord.
Okay.
It's a humble submission.
No, you do you have the judgment? 94.
No, my lord.
You'll have to look. I would have liked to have a look at that. Because that appears to be this Manoj Kumar Sharma, Southern, 1993 CRL.
Yes.
Wait,
2484, my lord.
248. It's not available. No?
Also,
I'll have to
it's not
tell
available.
library.
Does your lordship may take a
I have to
go through?
request my law firm get this judgment. He has quoted para also, but it appears to be a Jima matter. Needs to, yeah, reply man. Any reply if any. It is a recent decision, 20.
This one, this is 2020. Loss has been discussed in time. And there are also several other where it's been clear that the financier continues to be the owner until the loans have been paid.
Actually, this is what to understand who's the owner. You have to go into that, that
Yes.
what kind of a contract is that?
It's a
A
hire purchase. That's now.
Everything is within the contract, Lordship.
Just a minute. So you think that the magistrate was correct?
Well, it was correct because the report was called for by the police, and after going all through the reports and all the laws laid down, she has the fact remains that the petitioner is still at default. He's still a defaulter. Only by paying 2-3 EMIs out of 10-12 EMIs, one doesn't give
No,
the
they-
entitled right and submitting doesn't give the right to take possession of the vehicle. And now again, when I'm submitting, Malat, the bank doesn't have any objection provided all the dues.
The aspect of default was before the magistrate.
That was placed before the magistrate. My petition is there. I've also placed this statement of account there.
My Lordship, the grievance is that, Lordship, whether magistrate rightly decided on the issue of the default, Lordship. He had,
Inner findings there.
and because there are two applications for seeking Jima, in both the case, the report was called for. Wherein in my case, Lordship, report says that no further investigation was required. And I sought for a Jima under section 451 of the CRPC, stating that damage and all.
Let us do one thing, I'll keep it part heart. Little bit of it's almost it's
Yes,
complete.
we'll place
It's
the.
complete, because
Yes.
I'll also tell her because I love to do research, but I don't get time. So this aspect,
place.
that criminal, what happens because this kind of situations have arisen plentiful all over India.
All over the country, man.
All over India. And so and we'll also see this High Court judgment, what it has said. So what Madam has said that, okay, owner we know, okay. So Honorable Supreme Court has said this is the law.
This is
That owner,
Finance.
the financial remains. But whether in a Jima proceeding, the magistrate should give it to the bank or to the, because the magistrate cannot be a recovery agent,
No.
for the bank. So in a way, cannot be. But if that is legally right, he can. But whether, so we'll look for some laws. That will be fun. Because this judgment we must see, which he has referred and recent issue.
Man.
Before vacation, any date, Lordship.
After vacation. Only for a few more days,
You don't.
Actually,
I'll exercise myself
It's a
and
little
place.
tight before vacation. You can have, but it will be a little tight. Anyway, Matija.
Also, for that matter only, I'm placing if I come after vacation and we can the lordship.
Yeah, then you have sufficient time.
when we'll go to receive in because in last week, my lord,
12 days are still left.
when 10, this 10-12 days are crucial, my lord. These 10-12 days are crucial, my lord, for us, my lord, because
As your lordship pleases.
no, I leave it up to your lordship, my lord, and also
Lordship
to
pleases.
convenience of my learned.
Let it be after the vacation. You get sufficient time
Lordship.
to search.
Let it be remain as part-heard lordship.
It has to be part-heard only. I won't waste
Yes.
your effort.
Yes.
We have so many matters to handle. Use time, be wisely. Please hope learned counsel for the petitioner. Short order. I've also heard learned counsel appearing for the respondent.
2 months.
SDFC Bank. Respondent number 2.
Respondent number 2. M. Smith.
8th of January lordship.
The though arguments are addressed at length, but some issues and law points still remain, for which the matter is being kept part-heard. The parties, the learned counsels on both the sides are at liberty to place other relevant case laws. List on. How about 6-1?
Yes.
Just after reopening,
Yes,
as per mutual convenience.
Yes.
6-1.
6-1.
Matter is kept part-heard.
Part-heard go to bold print. Otherwise, it will waste your.
And deeply obliged.
Obliged.
Should we do jail? Mr. Doctor?
Well, I was appointed to the Amicus, but I'm not having any copy of the paper book like I get to be furnished.
Registry will give you.
Yes, ma'am. The person can be admitted, well, there are some other.
Yes. Sri Minnoy Doctor, learned counsel, is representing the convict appellant as amicus. This is the jail appeal preferred by the convict appellant so and so against judgment and order of conviction dated 6/5/24 passed by the learned additional session Sibahagar, convicting and sentencing him under 376 IPC. Details of RI 8 years, fine of 5,000, ID SI 2 months. The learned amicus submits that he has not yet received the copies. The registry shall furnish set of copies to the learned amicus. Another thing we'll need, case record has to be called.
Yes,
The
yes, sir.
original case record of sessions case number 22 of 2023 shall be requisitioned from the court of the learned additional session Justice Kibo Hagar. This since it's a 376, any informant is to be noticed? Necessary. Not necessary.
Notice may be issued to the informant. That is not.
Even the informant.
That can be made a party notice should go.
Now notice, he cannot send a notice obviously because it will be from the registry.
Yes.
Yes.
A notice shall also be sent from the registry to the informant of the case. Informant, victim will be a major in this case. Informant / victim. Informant and oblique or victim. That will be wrong. Informant / victim. They will understand. And if the informant comes, and then we can appoint another amicus. Then we can appoint another amicus.
Yes.
Informant. Anyway, do a good job.
Oblige, Lord.
Leave the matter. It's admitted for hearing.
Scan copy of PCR mapping.
Yeah, scan original. This is the matter in the orders call in the month of January. The month of January. or later, January or later. He's in custody, I think.
The TC has also come, my lord, so that will take some time.
In the month of January, the date to be fixed by the registry.
Oblige, your lordship.
Let us see whether we can do it.
Lordship, council is currently on the legs in court number 10, maybe taking out after some time.
Or maybe let us adjourn it today. Because we'll take one more matter actually, which is,
After some time, if
I think, let's call it a day as far as these two matters are concerned. Fix it, can we fix it after vacation? Because I don't know the subject matter, interim order, whatever, anything is there. Okay, skip for time.
time being.
Yeah.
Oblige.
May I please, your lord?
This matter, bottom.
Lordship, this is a case where we have challenged the proceeding, your lordship, initiated against us, your lordship, under various sections of Indian Penal Code as well, BNS, as well as your lordship, POCSO. If your lordship comes to page 19, where is the FIR, your lordship? Here, your lordship, so far as the charge sheet and the FIR goes, your lordship, there are 5 accused, your lordship, and main accused, your lordship, against whom the allegations are there, is our son, your lordship, who is a minor, your lordship, at a relevant point of time, and he is not before this honorable court. The rest of the family members are before this honorable court, and if your lordship takes up the FIR for a moment, your lordship, page 19.
Just a minute.
Lords.
That other matter is also there. I'm just planning. 45
Lords.
minutes are there. The petitioner in person, he's been, one matter is continuing. actually.
Lords,
He's come from Kolkata.
Lords.
So we have heard him, today is last actually. So that matter is there. I would have liked to hear him from 4 o'clock. But before that, that matter, you were, that goal matter, right? Goal matter. He had done his part. Your part is there. You're looking up. So that is there. This one and his matter. How do we plan it? I would have, because otherwise half an hour would be necessary, na, for you. At least half an hour would be necessary. Your friend from the other side is there? Yes. He will reply. Will half an hour be sufficient? Then, because otherwise, brief hearing should not make it a part otherwise. You can introduce the matter.
Lordship may kindly come to the
We can
FIR,
take it for another day.
page 19, your lordship. May I read, your lordship? Lords.
Quickly go through it.
With due respect, I beg to state that accused number 1 above named has love relations with my niece, namely Sri Majani Begum, and by inducing her for marriage, he has been maintaining physical relationship with her. She is now 6 months pregnant. In this regard, when we are trying for settlement of the matter with a family of the accused number 1, the accused person avoided the settlement and sent the accused number 1 to Kerala about 3 months ago. While our family members requested the accused persons and suggesting them for asking the accused number 1 to return and settle the matter, they have not given any importance in the matter and scolded us with filthy language and have been threatening us. My niece, namely Sri so-and-so, presently reads in class 9, but she could not go to school. At present, her age is about 15 years. Now, your lordship will kindly note that they have invoked various sections of BNS. Those are, your lordship, 81, 64, 2, that's rape, your lordship. And then cohabitation caused by a man deceitfully, that's section 81, 296, obscene acts and songs, and 351 is, your lordship, criminal intimidation. And POCSO, your lordship. Now, so far as the son is concerned, your lordship, probably these are the sections, your lordship, which can be invoked, your lordship, because there are specific allegation against him, your lordship. Now, your lordship, police investigated the matter. Then your lordship will kindly come to page 27. This is the charge sheet they have submitted. Page 27. Brief description is there, your lordship. the same. And then, your lordship, charge sheet was submitted against us, your lordship, under the same sections, your lordship.
POXO also.
POXO 6, your lordship, then rape, your lordship, everything, your lordship, they have. And shown as us as absconders, your lordship, although they have never tried to call us, your lordship. Then your lordship will kindly come to the order taking cognizance at page 40. Your lordship will kindly see the cognizance is taken under all the sections, your lordship, in which case was registered, your lordship, including section 6, 81, 64, 2M, 296, 351, 235 of BNS and section 6 of POXO Act. Now, your lordship, so far as these persons are concerned, the accused number, main accused number 1, he was not here before the learned court below, since he is a juvenile, your lordship. He is before the juvenile board, your lordship. Now, your lordship, this reflects, your lordship, complete non-application of mine on the part of the, your lordship, the learned trial court, your lordship. Now, on the face of the FIR, your lordship, these sections cannot be abstracted against us, your lordship. Now, your lordship may kindly see the nature of the allegation in the FIR. First of all, your lordship, that we have sent it to him to Kerala, your lordship. That's the one allegation. Then second allegation against us is that they have requested us for settlement, which we refused, your lordship. Now, on the basis of these two allegations against us, can there be a case under section 6 of POXO, your lordship?
Vicarious liability in POXO can come in what situation? Liability, do a main offense. Suppose there's the main offense. 17 is one. 17.
Lordship,
That is
17 is.
17 can come. Not reporting, I think.
Lordship.
I'm not mistaken, right?
Lordship.
17.
That's allegation is, that is not the allegation.
That is
your
another different. That's a different offense.
That's a different offense, your lordship.
And what else?
Lordship. Otherwise, on the face of the FIR, your lordship, these allegations will, and in your lordship, they cannot even, your lordship, these allegations cannot even be question of proving this, your lordship. My point is, your lordship, when there is an allegation, there must be some material, your lordship. And if we go through the objection filed by them, your lordship, that this is the same case they have brought in the form of objection, your lordship. Para, your lordship will kindly go through their objection.
Will not be able to complete, Mr. Potter.
Lordship, may, your lordship.
Keep it
because-
for another day.
Lordship.
Because if I go deeper, then it will waste your effort.
Lordship.
Lordship,
Only-
lordship, at the time of investigation, lordship, the about 5-6 numbers of witness were examined, lordship. This matters in the LCL, lordship. Let me kindly see, lordship. All the accused lordship, they implicated them, lordship. And they, the last line, lordship, the issue of the statement, lordship. They say that they have full guilty, lordship.
No, a person can be liable for abatement. A person can be liable under POXO for under 17, not reporting, trying to. But the main offense, unless it's that
This
is
main offense is done by.
unless it's an allegation of gang rape, it's not the case
Yes,
here.
that gang rape is not there.
That's
But
not the
they have
case.
come for the
So
quashing of
then
the FIR, lordship.
FIR, so
If
far as we
FIR
are
is goes,
concerned.
lordship, then everything will go, lordship. Then the main
No,
accused will
no,
also go, lordship.
that's not
They are
correct.
not saying that only they have come for only for this person, lordship. They come for quashing the everything, lordship.
Only for these persons.
No,
It will go by, the petty, it will be always in respect of the
everything
petitioner.
can go, lordship, if it is accepted, lordship. So, and my friend has
partly quashed also. It can.
Yes, yes.
partly can, but
Sections can also be quashed.
Lordship.
but they have to come actually for the reduction of the gravity of the section, lordship.
Anyway,
Yes, that can.
let us keep it for another day
Lordship.
to hear it properly. It takes some time. So, acha, another thing, records have come.
Records come, your
But
lordship.
otherwise, it saves time. by
Yes,
calling
your
for
lordship. Records has come, your lordship.
the what happened? Additional PPU also is appearing.
Yes, sir.
Additional PPU and for the information.
Yes, yes, sir.
Recent judgment says, your lordship, that police should act as a filter, your lordship. In those cases where there's
Every state.
lordship, and those cases where there is no possibility of conviction,
Registration, charge sheet,
lordship,
cognizance,
lordship.
charge framing, and then
Recent, few days back, this judgment has been delivered by the apex court, your lordship.
filter is necessary.
Lordship. So where there is no possibility of conviction, this should not be proceeded. your
There
lordship.
possibility is there, lordship. There lordship punishment may be less, lordship. Possibility is there, lordship.
So, though the learned counsels introduced the matter, but no proper hearing could be taken due to paucity of time. List the matter after vacation.
Lordship.
List the matter in the month of January on a date to be fixed by the registry.
Lordship may fix a date, your lordship.
Then suggested it.
Lordship.
Suggested it. After
In the first week of
before
January,
Bihu, after
before Bihu, your lordship, or
yeah, but vacation. I think.
and if your lordship can keep it as part of your lordship,
No, I'm not. I don't want to keep it because that's why with little bit of hearing will not be
Lord.
fair. Therefore, I stopped you because I don't want to waste your
Lordship,
effort on it.
Lord.
How about 2-0 after Bihu? 2-0.
2-0, lordship.
Let it be
22, your lordship.
22.
Oh, not 22, I will be out of it. 20, your lordship.
20. Okay. Fixed on B7. In the admission column only?
Lordship and admission.
What to do about this matter? Part out. This matter. Gold matter.
Gold matter, my lord,
I think no time.
my lord.
Deeply obliged. Lord.
Maybe part one, any date, maybe
Part
fixed, my
Who was taking it? And also addressed arguments
Excuse me.
and concludes the same, with a liberty to reply.
Fine.
The Boysal learned additional PP represents the prosecution, but the prosecution argument could not be taken due to paucity of time. Give the matter as part heard to bold list it, and you work out the date.
Lord, next Tuesday, my lord, if possible, my lord.
No, we can always fix it, but I don't know
Because it's
what will be the shape of matters. Okay.
my lord, why I'm praying, because it's a pardored method. That's why.
We'll keep it. Only we have to see whether prima facie theft allegation doesn't appear to be make out. They are suspecting it to be stolen, and habitual dealing with stealing property. That is something different from gold smuggling. And he also claims to have a receipt. So kindly look into this Customs Act. I had taken out. I requested.
Here, my lord, they might not move, my lord, that is
It is investigated by
petition
police.
also, man.
It is investigated by police.
Yes, ma'am.
What does the customs penal provision say about these things? We'll look into them.
I will do, my lord, on that point also, my lord.
Tuesday will be a little tight, but anyway, since you're wishing, I'm fixing it. Then we'll see.
My lord,
If we
even
cannot manage, then after vacation.
even if there is any penalty provision, then also it couldn't come, my lord, under Customs Act. 16, my lord.
Tuesday.
Tuesday, 16. Much obliged.
16, 12.
Matter is already, my lord, statement.
Interim orders.
Yes, my
Interim
lord,
order,
it is already statement. So, my lord, otherwise it may be fixed, my lord, after.
No, the hearing would be filmed otherwise. Means Lordship has heard already.
Only on the matter law point, my lord. The matter is on the.
Lordship had heard at length. Therefore, I'm urging for the earlier date. Otherwise, I wouldn't have any
So that
objection.
it is fresh in the mind.
Yes, yes.
55.
Yes.
Lordship, the matter in brief is that DBA, the adult.
What is this, man? Not over. Admissions.
Okay.
I have to start on another matter actually now. Yeah, tell me what is the matter. Keep it for another day, I think.
Lordship, this matter is fixed in the magistrate court on 20th of December. So on 15th, 16th or 17th, any date, Lordship, it can be fixed. Otherwise, I am also not praying to set aside the impugned order. Lordship, if 15 minutes is given to me,
now I'll submit and try to satisfy the court that order can be modified. I am not denying to make payment, just the way of maybe making payment, I'm just trying to modify.
Okay, keep it for Tuesday.
Lordship.
Tuesday or next 18th. But 18th, I don't know whether time will.
On Tuesday, Lordship.
Tuesday again, this matter also we have fixed actually. 16th.
16th, Lordship.
See, fix it.
Obliged, Lordship.
Come, you can. Here, they're here.
Lordships had heard me yesterday in IS 665. Lordship.
Okay, good. I'll take a 2 minutes break.
No, sure. After vacation.
Take it later. Any interim orders?
No. Public.
Please.
Your Honor, Lordship, item number 54, Your Honor. Was fixed for
Hearing it, I've reached in any case. Take a date in January.
Yes, Your Honor. After vacation.
After vacation.
Interim may be continued.
In January. On a
54, item
date to be
54.
fixed by the registry. No? Interim order shall continue. Problem.
My lord, item number 53.
53.
Yeah, first week of January.
Huh?
First week of
I'm not sure whether, anyway, that will decide. I may not be able to take up this matter, but I think I have passed an order as CBI just, then CBI just, in this.
in this matter.
Yeah. No. As with regard to this person.
Yeah.
Probably. I have not seen.
No order has been passed in lower court.
No, it's from CBI court, isn't it? It's from CBI court, I think.
Yes.
Is he a GST commissioner?
Yeah.
It's almost wrong. Anyway, we'll see later. Now, let's see January. Same
January, first week.
January on a date to be fixed by the registry.
Lordship, may I request for
52?
52, Lordship.
Yes.
Last week of January or date to be fixed by registry?
Okay. Last week of January on a date to be fixed by any interim order? No.
No. Obliged, Lordship.
Now you are free. So yeah, we can start.
Lordship, yesterday I made my submissions in IS 665, but I did not get the opportunity to place some orders of this honorable court. May I place them?
You can just place and then he'll start.
Lordship. Because with this I complete my submissions and then I will reply.
Your good friend from the other side is giving a lot of cooperation, isn't it? Yes.
Lordship,
He's been
we
there
are in a
whichever
slugfest
time we have given, he has been there. I appreciate.
Lordship,
anyway,
the first order I like to place before my lords is AB 17 of 25, passed by the Itanagar bench of this court, wherein the anticipatory bail was rejected.
I'll not go much,
No, I will not take
so that
much
we
of a
can,
time.
we can go through it. I'm just
Because of
marking
suppression of fact, Lordship. The next order is an order from this trial court, Lordship. Warrants have been issued against the respondent number 2 for non-appearance. Thirdly, Lordship, is an order from the Incheon court, where again a warrant has been issued for non-appearance. Now the case has been split and I think he is an absconder in the case. Yesterday, in his affidavit in opposition, he said that I have no knowledge about the Incheon or the Sejusa case, Lordship. I have placed the AB 12 of 23 wherein he got bail. That order I have placed before your Lordship. Lordship, I have placed some trial court orders which I was able to procure yesterday. If my lords see, the summons through SP Vishwanath remained unserved because he was untraceable. And he is still under warrants in this case. So this shows his post-bail conduct. He is evading trial, the process of law everywhere. Now, Lordship, he can make his submissions, then I will.
Yep.
May I, my lord? My lord, before starting my submission, my lord, I am appearing on behalf of Miss S. Nazneen, my lord. Some problem, my lord, she could not appear, my lord. If lordship permit, I may argue discuss.
Sure. You are fully capable.
Yes. Lordship, before going to the merit of this case, my lord, I want to apply this, who is this petitioner in person, my lord. Lordship, come to page 4, my lord, para 1. What is his introduction, my lord? Who is he? Here, second line, my lord, the applicant is the victim and de facto complainant in the Dibrugarh Police Station case number 442 of 2018 dated 3/4/2000.
Where are you reading? Page?
Page 4, para 1.
Of the petition?
Yes, ma'am. Yes, ma'am.
His
665.
petition? His petition?
665, ma'am.
665.
Immediate after custom.
Page?
4, my lord, para 1.
The applicant is a law-abiding citizen of
Yes, my lord. Second line,
Applicant is a, okay.
victim and the de facto complainant in the Dibrugarh Police Station case number 20. I'm not disputing that, my lord, he is a de facto complainant in the Dibrugarh PS case number. He is a complainant. He is a admitted fact. My lord, whether he is a victim, my lord. Now, lordship, come to the next page, my lord. Page number 5, my lord. Subpara A, that the mother of the de facto complainant is namely Bimola Devi Agarwal, who is the absolute owner of the excavator, my lord. Now, my lord, the definition 3WA of CRPC, my lord, who is defined, my lord, victim, my lord, is this petitioner is person fall under the category of the victim. When, my lord, there is no whisper about her status of her mother, my lord. As, my lord, in front of her name of her mother, my lord, no late is mentioned, my lord. This court may presume that, my lord, mother is alive. Is, my lord, his mother authorized him about to lodge this complaint? That is also not whisper in this petition, my lord. That means the court may presume that, my lord, there is no authorization, my lord, from his mother, my lord. Now, lordship, may come to the definition of the victim, my lord. CRPC, section 3, subsection WA, my lord, which is the definition. For once more. May I, my lord? Victim means a person who has suffered any loss or injury caused by reasons of the act or the omissions from which the accused person has been charged, and the express the victim includes his or her guardian or legal. Whether he is a guardian also of his mother? No. When his mother is still yet alive, how he can be a legal heir, my lord? And whether he suffered any loss or injury, my lord, that is also not explained, my lord. Then, my lord, how he can be a victim, my lord? That is my first summary. Now, lordship, make learn this petitioner is person several times apprised this court, my lord, me. A agreement was entered with me. That is not correct, my lord. The initial agreement was entered with his mother, my lord. Since she said Bimola Devi, my lord. The initial agreement, my lord.
Lordship, little bit of indulgence. No agreement was with the present respondent number 2, Lordship.
No, I am not that. I am where I am saying the present respondent is the
No, you
agreement.
said just.
No, I am the initial agreement.
Let him do it.
Right.
You note down the points and
Yes.
you reply.
With his mother, my lord. Considering that fact, my lord, this petitioner is person low locus standi, my lord, as per my knowledge, my lord. Lordship may once may come to the affair of the Dibrugarh case, my lord. Though petitioner repeatedly we are misrepresenting the court, my lord, we are misrepresenting the court. How the petitioner of the misrepresenting the court? He is not a victim. Then also he argued this case as a victim. He always emphasized this court. I am the victim. Initial agreement was entered with me, my lord. When I personally heard he several times uttered this word with me. He is not an authorized person of his mother. Then he is not a victim. No agreement was executed with me, with him, my lord. Lordship, page 62. This is the subject affair with the Dibrugarh case. The entire litigation is presently pending before this court. This is the subject affair, my lord. This is the Dibrugarh case, my lord. Lordship may come to page 63, my lord.
Yes.
There is, as per this allegation, my lord, they have the 4 excavator belonging to his mother, my lord. Those are some incidents where happened, my lord. Lordship may come to first para of the page 63, my lord, where is a number third line, my lord, serial number NL1C675. Lordship, mark this number, my lord. 676. Against this number, my lord, another case was already been lodged and registered, my lord, via number 9/27, Saljosa PS Arunachal Pradesh, my lord. That means, my lord, this excavator is the not subject matter of this FIR, my lord. The subject matter of this FIR is that, my lord, another two vehicle, my lord. Lordship may come to the fourth para, my lord. Fourth para. The fact of the other two excavator bearing NL1C797 and NL1B197 is still not known, my lord. Lordship, mark these two number also, my lord. Now, my lord, come to my initial bail petition, my lord. That is started from page 65, my lord. Lordship may come to page 68. The learned petitioner is person, my lord, raises this point, my lord. That is why I want to clarify, my lord, this point, my lord. Page 68, page 68, para number 3, my lord. That the accused petitioners there were two petitioners, my lord, initially. The present respondent one and another is another one, of manager or something, my lord. That the accused petitioner most respectfully beg to state that they are totally innocent and is no way connected with the Ellis offense, and they are not even named as an accused in the affair. The main accused in the affair is the Tagun Nari, son of Nari. That is entirely correct, my lord. The FIR named accused is Tagun Nari. What wrong I have mentioned? What misrepresent done before this honorable court, my lord? The FIR name accused is Tagun Nari. Yes, that is my submission. That is my statement. I am no way connected to this affair, my lord. That is my statement, my lord. Where is the misrepresentation, my lord? Then, lordship, come to the second bail petition, my lord, which is start from page 83, my lord. Lordship may come to page 85, my lord. Lordship, before going to that, my lordship may want for the one moment, my lord, lordship may come to my rejection order, my lord, which is on page, started from page 81 and ends page 82, my lord. The last para, which my learned petitioner in person also emphasized now.
Rejection order.
Yes, my lord, page 82, my lord. Last para.
Yes.
What is the observation of this honorable court while rejecting my bail petition, my lord? That at least one of the excavators involved in this case and he is alleged by the informant have to start selling the parts. That means, my lord, there is a link as per this rejection order. At least one excavator with me, my lord, where I am selling the parts of this vehicle, my lord. Now, lordship, come to my second bail petition. Why, my lord? Page number 85, para 4, my lord. Why I am in this para, my lord? How this learned petitioner is person misrepresent before this court on the face of this court, my lord. He alleged that on the previous day, my lord, that I am stating about the one excavator, my lord. It is not my say, my lord. It is the say of this court, honorable court. Honorable court observed that once we read, my lord. The petitioners beg to state that after lodging of the affair, petitioners prepared a bail application for granting pre-arrest bail before this honorable court along with Mr. So-and-so, AB number so-and-so, but same was rejected according to the present petitioner, fight ordered so-and-so on the ground that he has received one excavator involved to this case, my lord. Am I stated anything wrong, my lord? No, my lord. This is the observation of this court. So, my lord, I am quoted this part, my lord. That is my as per my statement, my lord. Now, landed petitioner is person who says that I am misrepresenting this court, only one vehicle, one excavator with me, and in my affidavit, my lord, I am saying the two vehicle. My lord, I have a right to keep silent. My learned friend also do to understand what is the criminal procedure is. Yes, he made some allegations. He should have to prove that allegation with the help of the prosecution, my lord. I have the constitutional right to keep silent, my lord, and I am silent. Why I will say that some ownership case is registered under so-and-so, I said that sir is so-and-so, my lord. It is not necessary for me. It is his responsibility, my lord. I am only elaborate the fact which is need to be necessary for my knowledge and for the appraisal of this court. And I stated that fact, my lord. Where is the misrepresent, my lord? Keeping silent and misrepresent before the court, two is different thing, two is distinct thing. My learned friend ought to understand that things, my lord. I am giving silent, my lord. That is my constitutional right, my lord. Now, lordship, come to page 86, my lord. para 6, my lord. And I am still intact with my earlier bail petition, my lord. I never suppress anything. I annex the copy of the bail petition, my lord. I annex the rejection order of this bail petition, my lord. Where is the misrepresentation, my lord, before this honorable court, my lord? That para 6, my lord, page 86, my lord, that the petitioner beg to state that under the circumstance narrated above, the petitioners was nowhere connected with the Elizabeth. I am again corroborating my earlier statement, my lord. I am no way connected with this Ellis crime, my lord. I am not involved in this crime. That is why, my lord, I am stating that, my lord. I am no way connected with this allegation, my lord. As far I parses those because initially what happened, my lord, those actual fact, even, my lord, if lordship appreciate the actual fact of this case, my lord, even lordship consider I am the second victim after that, my lord, him. Why, my lord, saying that, my lord? There is 4 excavator, my lord. Some Tagunnari has purchased or entered into agreement, I have no knowledge. One a person, I forgot this name, my lord, Gomdir person, my lord, he come before and enter into agreement for sell this, my lord. In that agreement, a portion was a pair in para 4 or something, my lord, there is written a part, my lord. Where is that? He produced the original, handed about the original document, my lord. That might be, I am not disputing that, my lord. Whatever written is written. That might be due to the copy paste, my lord, something that misinterpretation is come, my lord, that I am also involved in this case, my lord. That when that after the granting this bail petition, my lord, this petitioner is person lodged an FIR before the, my lord, Lotashil PS case number, my lord. I am going to that, my lord, and I am still intact, my lord, on this submission. Now, lordship may come to, my lord, the Lotashil PS case, my lord. That is not need, my lord, necessary, my lord, Lotashil FIR, yes, my lord, lordship page 108, my lord. This is, my lord, Lotashil. And, my lord, I may apprise this court, my lord, this may not be subject matter of this application, my lord, as this is a different case, my lord. So, my lord, in this case, my lord, after investigation police, my lord, what the police was submitted the charge sheet after conclusion of the investigation, my lord. What is the finding of the police, my lord? Once my lordship may look into, my lord, which started from page 120, my lord. Hence, my lord, relevant page is, my lord, 125, my lord. Lordship is there, my lord. Page 125, my lord. Page start from 120 and relevant portion is, my lord, page in 125. Where, my lord, second para, lordship is 125, there.
Yes.
Yes, my lord. Second para, my lord, where this portion is mentioned from the perusals of the sales agreement of the sale between the Sri Korkan Gomdir, the first party, and Monos Kumar Bora, this is me, my lord. It is observed that in the 4th para of the said agreement, it is mentioned that seller first party has already handed over the physical possession of the scheduled vehicle. That is the, my lord, actual behind the kahani, what I am pointed out earlier, my lord. To the purchaser, along with the original copy of the relevant document page relating to the scheduled vehicle. On contrary, during the investigation, it come to the document. It's come.
No, you are right. On the contrary, during investigation, it comes.
During the investigation, it's come to light that the original documents of the aforesaid scheduled vehicle are with the informant and the same have been seized in connection with the case on being protection by the informant. That is the finding. Then, my lord, allegation is basically that I prepared a forged document on bad date. Lordship may apply this through point, my lord. I prepared a forged document. On the based upon this document, this honorable court granted me bail, my lord. Whether the finding the para number 3rd and 4th can appreciate anything about that, my lord? May I read, my lord? What, my lord, conclusion of the investigation of the police, my lord? In course of the investigation, the expert opinion with regard to the comparisons of the specimen handwriting signature of the Sri Monos Bora, this is my signature, my lord. My specimen signature taken by the police, my lord. It emphasized that, my lord, I am cooperating with the investigation, my lord. That of the signature made by Sri Monos Kumar Bora in the sales agreement of the sale has been received in report number so-and-so, dated so-and-so, issued by Srimati Monomi Deka so-and-so, scientific officer so-and-so, question document division so-and-so, so-and-so. It is opined that the specimen signature of Sri Monos Bora matched with the signature made in the sales agreement of the sale, my lord. Obviously, it will be matched, as this is my signature, my lord. Now, next, this is interesting. During the investigation, it came to light that the accused Sri Monos Bora had submitted the fraudulent deed of agreement for the sale before the Honorable Guwahati High Court. while filing the anticipated bail petition so and so, arising out of so and so, all the informant mentioned in the affair that the Siri Nobokanto Oza, notary, Gopta Pasam, Vishwanath Chariali, register number so and so, was also part of the conspiracy as he helped the accused Siri Monos Bora to create and notarize the false fraudulent agreement on back date, but the incident did not happen under the territorial jurisdiction of the. So, my lord, the police never approached the notary, my lord, who may emphasize, my lord, whether these documents was prepared, manufactured documents on a backdated, my lord. That is not even a subject matter of the charge sheet, my lord. Lordship may appraise my point, my lord. In the trial, my lord, there is nothing in this case, my lord. I may be convicted, my lord. There is not even a remote chance, my lord, on conviction, my lord. Now, this learned petitioner, his person, my lord, come before this court based upon this charge sheet, my lord. He want to apprise this court, my lord, that I manufactured a document. This is the finding that I may manufacture a document, my lord? Is anywhere whisper in this charge sheet, my lord, that I manufactured this document, my lord? There is nothing, my lord, about the manufacturing of the document, my lord. Even, my lord, if Gomdi, my lord, who is the first party, my lord, even his signature also taken, my lord, then also his signature is not mismatched, my lord, then also may something we may say that, my lord. That is also not there, my lord. How can be this? There is no even a remote chance, my lord. Now, my lord, learned friend, my lord, how cleverly, my lord, play with this court, my lord. The order dated, my lord, passed, the cognizance order passed by the learned trial court, my lord, which is page 129, my lord. It is start from 129, my lord. Where cognizance is taken? Cognizance is taken, then what, my lord? Am I convicted, my lord? He ought to have apprised this, my lord, any person, including the accused, until and unless proven guilty, I am the innocent. That is the basic jurisprudence of the law, my lord. That is the basic of the law. I am innocent person. Only take cognizance, my lord. Lordship may come to page 132, my lord. How this petitioner is play with this court, my lord. Lordship may heard several things. RTI activists, PIL activists, my lord. This is the first time, my lord, I am hearing a FIR activist, my lord. He is lodging plenty of FIR, my lord, against me, my lord. Even against my doctor also, my lord, who prescribed me, given a medical certificate, that due to some medical condition, my lord, I could not appear before the police, my lord. That is the situation, my lord. Lordship, come to page number 132, my lord. Last part, my lord. Send a copy of this order to this Honorable Registrar of Vigilance, Honorable Guwahati High Court, Superintendent of Police of Dibrugarh for their kind information, my lord. Now, my lord, the learned friend, learned petitioner in person, come within another IA, my lord, to call a status report from the registry, my lord. Can, my lord, a judicial magistrate firstly direct the registry, my lord, to lodge and complain against me? Is there any investigation made by the registry, my lord? Why registry will lodge a complaint against me, my lord? Is there a prima facie? The registry concluded a complaint, registry investigate the matter. Sorry. Sorry, I'm still. My lord, then, my lord, that is my point, my lord. This IA has nothing to do with this case, my lord. Now, my lord, my just learned petitioner also pointed out my objection, my lord, filed by me, my lordship might be, my lord, running page 134 instructed this, my lord, and basically he raises objection on page 135, para number 3,
134,
135, para number 3. Lordship.
Number 3.
Yes, my lord, 135, para
Oh, yeah.
3, my lord. There, my lord, I mentioned two vehicle name, my lord, number, my lord. Whatever I earlier stated in the Dibrugarh PS, my lord. These two vehicle, my lord. One, I annexed with my bail petition, my lord. Another, which was the subject matter of the Arunachal PS case, my lord. Some PS case of the Arunachal, my lord. Wait, where is my forgery, my lord? Why this petition, my lord? When there is in the face of the record, there is no forgery, my lord. How he can become before this court? for with the allegation that I am the forgery, my lord. I have a right to keep silent. It is his burden of proof lies on him, not me, my lord. He should have to bring proof. I am the not person who went come before the police and come before the court and say that I am not involved in this case. As my lord, why I am pointing out this repeatedly, my lord. Earlier that he pointed out one point. If I am not innocent, I have to take hand with him and the help his investigation. Why I will help him, my lord? I have a constitutional right to keep silent, and I am silent. It is his duty to convict this person who are culprit. But I am not the culprit, my lord. Now, my lord, before going to the law point, my lord, whether this petition is maintainable or not, my lord, I want to point out the conduct of this petitioner is person, my lord. Though I ought not to have raised the issue, my lord, but this petitioner person compel me to raise the issue. My lord. Why? My lord? Lordship once may peruse, my lord. Order dated 13/6/2025, passed in IN number 799/2023, my lord.
Order IN
799/2023. Order dated 13/6/2025, my lord. Lordship may pardon me, my lord. I ought to not raise this issue, my lord, but I am raising this issue, my lord. There is something, so my lord. Lordship also have to know
IA 799.
what is the conduct of this petitioner person, my lord.
IA 79.
799/2023. Order dated 13/6/2025. This is a court order, my lord. No, court order. Court order, my lord. Order sheet, my lord. Order dated 13/6/2025, my lord. Lordship is there?
Yes, just.
Yes.
Judgment.
I will not take much time of lord.
Yes, go ahead.
Before arguing before this bench, my lord, this matter was heard at length before the Honorable Justice Mridul Kulitam. I am taking the name, my lord. This court restrict this petitioner's person only to argue whether this petition in the present form maintainable as per law or not. When the 799/2023 case, Mr. Rajesh Sonar argued this case by citing the case law Abdul Basit versus the Muhammad Abdul so and another, my lord. Then, my lord, what happened, my lord? That is interesting, my lord. After that, this learned petitioner is person started to avoid this court, my lord. Either he taken time or he undertakes the court, he will appear physically, then he comes through a video conference, my lord. And anyhow, my lord, he would take the adjournment from this court, my lord. Why, my lord? This is the main thing, my lord. Why? This is the letter, my lord. What this petitioner is person to write the Chief Justice of this honorable court. What is his prayer, my lord? Surprising, my lord. What is his prayer? His prayer is that prayer for listing of the above referred case separately before a senior bench and directed for its expeditious disposal, my lord. What is emphasized, my lord? Transpires, my lord. He had no intention to argue before this court, my lord. He want a senior bench to make his argument. What is this, my lord? And that is the conduct of this petitioner is person. Now, my lord, come to the fact of the maintainability of this court. My initial submission is that, my lord, this petition preferred under section 439 subsection 2, my lord. This petition is not maintainable at all, my lord. Before going to that point, my lord, this learned friend also produced some documents, my lord, regarding the trial going on, my lord. My lord, the subject case is Dibrugarh PS case, my lord, where investigation is still not concluded, my lord. This is the case of the Lotashil PS case, my lord. And my lord, the learned magistrate issue summon to me. This summon never served upon me. The NBW was issued. Police failed to execute the NBW. The learned magistrate ought to have show cause. The officer in charge or the superintendent of the police, why they failed to execute the NBW. Even, my lord, cancel my bail bond, my lord. But when, my lord, though notice was served to me, why I will appear, my lord, before the trial court, my lord? I have no knowledge. my lord. Lordship may come to the, my lord, law point of this case. My lord, this petition under section 439 subsection 2, my lord, for the cancellation of bail, my lord. But, my lord, what is the ground taken by this learned petitioner in person, my lord? Lordship may come to page 23, my lord, page 23 to till, my lord, last, my lord, page 26, my lord. I number, my lord, 665, my lord. Page 23, my lord.
Another 15 minutes? 10,
My lord, my lord, my lord.
No,
I'm
otherwise we'll keep it another day.
my lord, I will conclude in my. No.
Sign orders.
Yes. Basically, my lord, this petition is application is preferred by challenging on the ground of the bail was granted on the strength of fake, false, fraudulent manufacture agreement, and the document is perverse, arbitrary, and cannot be sustained in the eye of the law. And, my lord, if lordship may peruse the ongoing para, my lord, below part, my lord, basically two. One is the arbitrary, the order itself is arbitrary. The order where the bail was granted is perverse. The order which was granted on considering the manufactured document. But this is his ground, my lord. This is not the case, my lord, where the post conduct after granting bail by this honorable court. This is the only based upon the arbitrary manufactured documents and perversity of this order. I am not disputing the right of the petitioner, my lord. He has every right to test a order of this honorable court or any other court, my lord, but it should not before the same court. It ought to have before the superior court. Lordship also made in query, my lord, last occasion. Though there is a bar under section 362, is this court and under inherent jurisdiction of 482 can override that bar? I'm later on address this court on this point also, my lord. Before that, my lord, I have a recent judgment of this honorable apex court, my lord, which is 2025 judgment, my lord. In the month of August, my. I will not take lordship much time, my lord. Lordship may directly come to page number. There is page number 7, my lord. Para 14. Para 14. Lordship is there. ML. At the outset, we must clarify that the setting aside an order granting bail and the cancellation of bail are two distinct concepts. But that is the subject matter of this case. Both are two distinct concepts, my lord. Cancellation of bail, yes, he has a right, but it should be based upon my post conduct after granting the bail, whether I violate any condition of the bail or not. And the other fact is that, my lord, he may test this order on the ground of perversity, on the ground of arbitrary, on the ground of by way of taking bail, by way of misrepresentation of this court, my lord. He may go. He has every right. He challenges this order, my lord. Not before that court, my lord, because, my lord, the bar put by 362 of the CRPC, my lord. The bar put by the 362, my lord, only given the option this honorable court to rectify the any mistake, clerical or numerical. That is only. Otherwise, no, my lord. Lordship may also come to the page para 16, my lord. Discussion of the so and so court number underscore that order granting bail can be based on illegality, perversity, arbitrariness, and being based on unjustified material. While it has said the order so and so, so I will not take lordship time. Lordship may directly come to page 12, my lord, para number 19. What the observation? The honorable apex court.
Para 19.
Yes, my lord, para 19, page 12, my lord. Which, my lord, honorable apex court, my lord, para wise, make observation. What do we do a court when the such situation is arises, my lord? Page 12, para 19.
I think you're getting repeat print. Page 12 is not here.
My lord,
Is 11 is coming again.
my lord,
It
my.
was a repeat print. Anyway, never mind, you read it.
Yes, my lord. I will provide this copy, my lord.
I'll locate the copy.
Yes, my lord. The principles which emerge as a result of the above discussion are as follows. Point number 1, an appeal against the grant of bail cannot be considered to be on the same footing as an application for the cancellation of the bail. That is my point. The court concerned must not venture into a threat bar analysis. My lord, this is important. Threat bar analysis of the evidence adduced by the prosecution. The merits of the such evidence must not be adduced at the stage of bail. Now, subpara Roman 4, my lord. An appeal against the ground of bail may be entertained by a superior court on the ground such as perversity, illegality, inconsistency with law, relevant factors not been taken into consideration, including gravity of the offense and impact of the crime. And my lord, Roman 5, my lord. However, the court may not take the conduct of an accused, that is important, subsequent the grant of bail in the consideration while considering an appeal against the grant of the bail, my lord. That is, my lord, this honorable the apex court, my lord, clarify two different things, my lord. One is the conduct of, that may come under section 392 subsection 2, my lord, and the appeal to test whether this order is perverse, whether this order is arbitrary, whether any considering of the law which is not actually correct, whether the order was passed based upon a manufactured document, fraudulent. Now, lordship, the most important judgment is my lord, what my landed friends also submitted before this honorable court, my lord. If lordship permit, my lord, I will again submit this, my lord. This already with the record, my lord. This is the case, my lord, where our High Court judgment was challenged, my lord. Para 1, my lord. Running page 758, para 1. This special leave petition arises out of the judgment and order passed by the High Court of Guwahati at Guwahati in so and so, dated so and so, whereby and whereunder the High Court has cancelled the bail granted to the petitioner herein by the High Court. This is the case, my lord, where he squarely covered everything, my lord.
Para 1.
Para 1, my lord.
Para 1.
Yes, ma'am. Para 1. Okay. Para 1. Well, initially, this High Court grant bail. Subsequently, based upon a miscase, my lord, said bail was cancelled. Based upon that misinterpretation of law, my lord. That is the main. Now, lordship, come to page 761, my lord, para 14. That is explain, my lord, on what condition a 439(2) application can be live before this court. Page 761, para 14, my lord. Lordship is there. Am I read, my lord?
Yes.
Yes, ma'am. Under chapter so and so, section 439, subsection 1 empowers the High Court as well as the Court of the Session to direct any accused person to be released on the bail. Section 439(2) emphasizes the High Court to direct any person who has been released on bail under section so and so, under chapter so and so of the court, be arrested and committed to the custody, that is the power of the cancellation of the bail granted to an accused person. Generally, the ground for the cancellation of bail broadly are, my lord. 1. The accused misuses his liberty by indulging in the similar criminal activity. Whether am I involved in the similar activity of the crime? No. Number 2, interference with the course of the investigation. Am I interfering with the investigation in the Dibrugarh PS? No. Number 3, my lord, attempt to tamper with the evidence or the witness. Is there any whisper about the tampering of the witness? No. Threatens witness or indulging in the similar activity which would hamper the smooth investigation. Am I threatening? Is there any whisper? No. There is likelihood of his fleeing to the another country. Am I flying to another country? No. Is there likelihood? No. The attempt to make himself scarce by going the undergoing become the unable to the investigation agency. I am always available to the investigation agency, my lord. Attempts to place himself beyond the reach of his surety, etc. This ground is not exclusive, my lord. I am not involved in any such things, my lord. Now, lordship may come to my lord. Page 763, my lord. I will take, my lord, only 2 or 3 minutes, my lord. 763, my lord, point number, para number 19, my lord. No, that is not necessary. Lordship may directly may come to my lord 764, para 20, my lord. In this instance case, the respondent herein had filed the criminal miscellaneous petition before the High Court seeking the cancellation of bail on the ground that the bail was obtained by the petitioners herein by the gross misrepresentation of the fact, misleading the court and indulging in the fraud, which is my learned friend also raises these issues. Thus, the petitioner challenged the legality of the ground of the bail and required the bail order to be set aside on the ground of that being perverse in law. Such determination would entail eventually cancellation of the bail. The circumstances brought on record did not reflect any situation where the bail was misused by the petitioner of the accused. There is also nothing, my lord, I misused the condition of the bail, my lord. Therefore, the High Court could not have entertained the said petition and cancelled the said bail on the ground of perversity in the law, my lord. That is the main thing, my lord. This court ought not to have cancelled my bail petition on the ground of the perversity, arbitrarily, based on the fraudulent documents which are passed as per the allegation. Now, lordship, whether the lordship's query, whether the section 362, section 482 override the mandate of the section 362. That is discussed on 765, para number 23, my lord.
Don't.
My lord.
482 won't override 360.
Yes, my lord. It is like categorical, my lord. Even, my lord, para my lord 25, my lord. It is a well settled position of the law that what cannot be done directly cannot be done indirectly, my lord.
That's true.
When the law bar anything, my lord, this court cannot override these things by using the inherent power of this honorable court, my lord. My lord, that is my submission, my lord. This petition is not maintainable at all on the point of law, even not maintainable on the fact as alleged in this petition, my lord. Yes, this petitioner, this person have the right. And my lord, another important thing which I want to point it out before a lordship, my lord. This learned friend emphasized one point also, my lord. Why till then, after lodging the affair before the Dibrugarh PS is still not concluded in the form of the charge sheet, my lord. Though I am not going through the investigation, my lord, my only, my lord, understanding says, my lord, how can be police concluded the investigation, my lord? The fraud was committed with his mother, my lord, not him. His statement will do nothing to the police, my lord. His mother ought to appear before the police and give the statement, my lord. Then only, my lord, police can conclude the investigation, my lord. Otherwise, police can't. Police hand is tight, the investigation officer's hand is tight, my lord. How they can, my lord, conclude the investigation, my lord? My lord, I rest my submission, my lord.
Lordship.
We'll fix a date.
Lordship, just
No.
I'm not submitting, Lordship.
No, see, I'm already 15 minutes beyond schedule. So take a
uh,
date. Take a date.
Lordship, can I reply tomorrow, Lordship?
To day after tomorrow. When should we fix it? Because public prosecutor. You can apply, submit through VC also, if you want to go back to Kolkata, isn't it?
Lordship, I will like to address my lords in person. May not tomorrow, maybe after day after.
Next week. Next week again. Voting. Cancellation matter. No. Either Thursday or Monday. Tuesday.
Next week, yeah.
Tuesday.
Lordship, if I get an opportunity on Thursday, I will be highly honored, Lordship. Because the matter have been running for the last week and I will be pressing it.
Yes, that'll do. Because we are on a different trajectory actually here, more than seeing the investigation. We are on this bail cancellation grounds, mostly. So we'll do one thing then. Thursday at 2 p.m. I'll give you half an hour.
Lordship, more than enough.
I'll fix it in the order only.
Lordship, just Learned Council has stated a email to Guwahati High Court
Can you finish?
Registry.
You can file written submission if you want. Or should I fix it on Tuesday?
No,
You can submit written argument, he can submit written submissions
Yes.
and oral arguments half an hour,
Yes.
because this is coming.
Lordship,
Thursday,
both the cases, their submissions are on the
12
same Abdul Bashid case. Lordship.
Thursday, 11.
Thursday,
11.
this Thursday. What time? 2 o'clock. 2 o'clock, okay. 2 to 2:30, and in the meantime, if you want to furnish the written permission, you can.
Lordship, what surprises me, an email to the registry has landed up in the hands of the learned counsel.
He, my lord, himself forwarded to the counsel of the petitioner, my lord. He might be forget, my lord.
How can I?
Though I will bring you proof. Oblige me.
Sure, obviously.